Scott v. Sandford as Curtis dissenting. I dissent from the opinion pronounced by the Chief Justice, and from the judgment which the majority of the court think it proper to render in this case. The plaintiff alleged, in his declaration, that he was a citizen of the state of Missouri, and that the defendant was a citizen of the state of New York. It is not doubted that it was necessary to make each of these allegations, to sustain the jurisdiction of the circuit court. The defendant denied, by a plea to the jurisdiction, either sufficient or insufficient, that the plaintiff was a citizen of the state of Missouri. The plaintiff demurred to that plea. The circuit court adjudged the plea insufficient, and the first question for our consideration is, whether the sufficiency of that plea is before this court for judgment, upon this writ of error, the part of the judicial power of the United States, conferred by Congress on the circuit courts, being limited to certain described cases and controversies. The question whether a particular 60 U.S. 393, 565 case is within the cognizance of a circuit court, may be raised by a plea to the jurisdiction of such court. When that question has been raised, the circuit court must, in the first instance, pass upon and determine it. Whether its determination be final, or subject to review by this appellate court, must depend upon the will of Congress, upon which body the Constitution has conferred the power, with certain restrictions, to establish inferior courts, to determine their jurisdiction, and to regulate the appellate power of this court. The 22nd section of the Judiciary Act of 1789, which allows writ of error from final judgments of circuit courts, provides that there shall be no reversal in this court, on such writ of error, for error in ruling any plea in abatement, other than a plea to the jurisdiction of the court. Accordingly it has been held, from the origin of the court to the present day, that circuit courts have not been made by Congress the final judges of their own jurisdiction in civil cases, and that when the record comes here upon writ of error or appeal, and, on its inspection, it appears to this court that the circuit court had not jurisdiction, its judgment must be reversed, and the cause remanded, to be dismissed for want of jurisdiction. It is alleged by the defendant in error, in this case, that the plea to the jurisdiction was of sufficient plea, that it shows, on inspection of its allegations, confessed by the demurrer, that the plaintiff was not a citizen of the state of Missouri, that upon this record, it must appear to this court that the case was not within the judicial power of the United States, as defined and granted by the Constitution, because it was not a suit by a citizen of one state against a citizen of another state. To this it is answered, first, that the defendant, by pleading over, after the plea to the jurisdiction was adjudged insufficient, finally waived all benefit of that plea. When that plea was adjudged insufficient, the defendant was obliged to answer over. He held no alternative. He could not stop the further progress of the case in the circuit court by a writ of error, on which the sufficiency of his plea to the jurisdiction could be tried in this court, because the judgment on that plea was not final, and no writ of error would. Like, he was forced to plead to the merits. It cannot be true, then, that he waived the benefit of his plea to the jurisdiction by answering over. Waiver includes consent. Here, there was no consent. And if the benefit of the plea was finally lost, it must be, not by any waiver, but because the laws of the United States have not provided any mode of reviewing the decision of the circuit court on such a plea, when that decision is against the defendant. This is not the 60 U.S. 393, 566 law. Whether the decision of the circuit court on a plea to the jurisdiction be against the plaintiff, or against the defendant, the losing party may have any alleged error in law, in ruling such a plea, examined in this court on a writ of error, when the matter in controversy exceeds the sum or value of $2,000. If the decision be against the plaintiff, and his suit dismissed for want of jurisdiction, the judgment is technically final, and he may at once sue out his writ of error. Smallin v. Torrance, 9 Wheat, 537. If the decision be against the defendant, though he must answer over, and wait for a final judgment in the cause, he may then have his writ of error, and upon it obtain the judgment of this court on any question of law apparent on the record, touching the jurisdiction. The fact that he pleaded over to the merits, under compulsion, can have no effect on his right to object to the jurisdiction. If this were not so, the condition of the two parties would be grossly unequal. For if a plea to the jurisdiction were ruled against the plaintiff, he could at once take his writ of error, and have the ruling reviewed here, while, If the same plea were ruled against the defendant, he must not only wait for a final judgment, but could in no event have the ruling of the circuit court upon the plea reviewed by this court. I know of no ground for saying that the laws of the United States have thus discriminated between the parties to a suit in its courts. It is further objected that as the judgment of the circuit court was in favor of the defendant, and the writ of error in this cause was sued out by the plaintiff, the defendant is not in a condition to assign any error in the record, and therefore this court is precluded from considering the question whether the circuit court had jurisdiction. The practice of this court does not require a technical assignment of errors. See the rule. Upon writ of error, the whole record is open for inspection, and if any error be found in it, the judgment is reversed. Bank of U.S. v. Smith, 11 Wheat, 171. It is true, as a general rule, that the court will not allow the party to rely on anything as cause for reversing the judgment, which was for his advantage. In this, we followed an ancient rule of the common law. But so careful was that law of the preservation of the course of its courts, that it made an exception out of that general rule, and allowed the party to assign for error that which was for his advantage, if it were a departure by the court itself from its settled course of procedure. The cases on this subject are collected in Back Baby, Error H4. And this court followed this practice in Calprin v. Van Norden, 60 U.S. 393, 567 to Cranch, 126, where the plaintiff below procured the reversal of a judgment for the defendant, on the ground that the plaintiff's allegations of citizenship had not shown jurisdiction. But it is not necessary to determine whether the defendant can be allowed to assign want of jurisdiction as an error in a judgment in his own favor. The true question is not what either of the parties may be allowed to do, but whether this court will affirm or reverse the judgment of the circuit court on the merits, when it appears on the record, by a plea to the jurisdiction, that it is a case to which the judicial power of the United States does not extend. The course of the court is, where no motion is made by either party, on its own motion, to reverse such a judgment for want of jurisdiction, not only in cases where it is shown, negatively, by a plea to the jurisdiction, that jurisdiction does not exist, but even where it does not appear, affirmatively, that it does exist. Pecunia v. the Pennsylvania R.R. Company, 16 House, 104. It acts upon the principle that the judicial power of the United States must not be exerted in a case to which it does not extend, even if both parties desire to have it exerted. Cutler v. Rake, 7 House, 729. I considered, therefore, that when there was a plea to the jurisdiction of the circuit court in a case brought here by writ of error, the first duty of this court is, if you a spont, if not moved to it by either party, to examine the sufficiency of that plea, and thus to take care that neither the circuit court nor this court shall use the judicial power of the United States in a case to which the Constitution and laws of the United States have not extended that power. I proceed, therefore, to examine the plea to the jurisdiction. I do not perceive any sound reason why it is not to be judged by the rules of the common law applicable to such pleas. It is true, where the jurisdiction of the circuit court depends on the citizenship of the parties, it is incumbent on the plaintiff to allege on the record the necessary citizenship, but when he has done so, the defendant must interpose a plea in abatement. The allegations whereof show that the court has not jurisdiction, and it is incumbent on him to prove the truth of his plea. In Shepherd v. Grates, 14 House, 27, the rules on this subject are thus stated in the opinion of the court, that although, in the courts of the United States, it is necessary to set forth the grounds of their cognizance as courts of limited jurisdiction, yet wherever jurisdiction shall be averred in the pleadings, in conformity with the laws creating those courts, it must be taken, prima facie, as existing, and it is incumbent 60 U.S. 393, 568 on him who would impeach that jurisdiction for causes or the pleading, to allege and prove such causes, that the necessity for the allegation, and the burden of sustaining it by proof, both rest upon the party taking the exception. These positions are sustained by the authorities there cited, as well as by Wycliffe v. Owings, 17 House, 47. When, therefore, as in this case, the necessary averments as to citizenship are made on the record, and jurisdiction is assumed to exist, and the defendant comes by a plea to the jurisdiction to displace that presumption, he occupies, in my judgment, precisely the position described in Bacon AB, abatement. Abatement, in the general acceptation of the word, signifies a plea, put in by the defendant, in which he shows cause to the court why he should not be impleaded, or, if at all, not in the manner and form he now is. This being, then, a plea in abatement, to the jurisdiction of the court, I must judge of its sufficiency by those rules of the common law applicable to such pleas. The plea was as follows, and the said John F. A. Sandford, in his own proper person, comes and says that this court ought not to have or take further cognizance of the action aforesaid, because he says that said cause of action, and each and every of them, if any such have accrued to the said Dred Scott, accrued to the said Dred Scott out of the jurisdiction of this court, and exclusively within the jurisdiction of the courts of the state of Missouri, for that, to wit, the said plaintiff, Dred Scott, is not a citizen of the state of Missouri, as alleged in his declaration, because he is a Negro of African descent. His ancestors were of pure African blood, and were brought into this country and sold as Negro slaves, and this the said Sandford is ready to verify. Wherefore, he prays judgment whether this court can or will take further cognizance of the action aforesaid. The plaintiff demurred, and the judgment of the circuit court was, that the plea was insufficient. I cannot treat this plea as a general traverse of the citizenship alleged by the plaintiff. Indeed, if it were so treated, the plea was clearly bad, for it concludes with a verification, and not to the country, as a general traverse should. And though this defect in a plea in bar must be pointed out by a special demurrer, it is never necessary to demur specially to a plea in abatement. All matters, though of form only, may be taken advantage of upon a general demurrer to such a plea. Chili on place, 465. The truth is, that though not drawn with the utmost technical accuracy, it is a special traverse of the plaintiff's allegation 60 U.S. 393, 569 of citizenship, and was a suitable and proper mode of traverse under the circumstances. By reference to Mr. Stevens' description of the uses of such a traverse, contained in his excellent analysis of pleadings, Staff, on place 176, it will be seen how precisely this plea meets one of his descriptions. No doubt the defendant might have traversed, by a common or general traverse, the plaintiff's allegation that he was a citizen of the state of Missouri, concluding to the country. The issue thus presented being joined, would have involved matter of law, on which the jury must have passed, under the direction of the court. But by traversing the plaintiff's citizenship specially, that is, diverting those facts on which the defendant relied to show that in point of law the plaintiff was not a citizen, and basing the traverse on those facts as a deduction therefrom, opportunity was given to do what was done, that is, to present directly to the court, by the demurrer, the sufficiency of those facts to negative, in point of law, the plaintiff's allegation of citizenship. This, then, being the special, and not the general or common traverse, the rule is settled, that the facts thus set out in the plea, as the reason or ground of the traverse, must of themselves constitute, in point of law, a negative of the allegation thus traversed. Stephen on place, 183, chapter on place, 620. And upon a demurrer to this plea, the question which arises is, whether the facts, that the plaintiff is a Negro, of African descent, whose ancestors were of pure African blood, and were brought into this country and sold as Negro slaves, may all be true, and yet a plaintiff be a citizen of the state of Missouri, within the meaning of the Constitution and laws of the United States, which confer on citizens of one state the right to sue citizens of another state in the circuit courts. Undoubtedly, if these facts, taken together, amount to an allegation that, at the time of action brought, the plaintiff was himself a slave, the plea is sufficient. It has been suggested that the plea, in legal effect, does so avert, because, if his ancestors were sold as slaves, the presumption is they continued slaves, and if so, the presumption is, the plaintiff was born a slave, and if so, the presumption is, he continued to be a slave to the time of action brought. I cannot think such presumptions can be resorted to help out defective avertments in pleading, especially in pleading in abatement, where the utmost certainty and precision are required. Chili on place, 457. That the plaintiff himself was a slave at the time of action brought, is a substantive fact, having no necessary connection with the fact that his parents were sold as slaves. For they might have been sold after he was born, or the plaintiff himself, if once a slave, might have 60 U.S. 393, 570 became a freeman before action brought. To avert that his ancestors were sold as slaves, is not equivalent, in point of law, to an averment that he was a slave. If it were, he could not even confess and avoid the averment of the slavery of his ancestors, which would be monstrous, and if it be not equivalent in point of law, it cannot be treated as amounting thereto when demurred to, for a demurrer confesses only those substantive facts which are well pleaded, and not other distinct substantive facts which might be inferred therefrom by a jury. To treat an averment that the plaintiff's ancestors were Africans, brought to this country and sold as slaves, as amounting to an averment on the record that he was a slave, because it may lay some foundation for presuming so, is to hold that the facts actually alleged may be treated as intended as evidence of another distinct facts not alleged. But it is a cardinal rule of pleading, laid down in Dowman's case, 9 Representative, 9b, and in even earlier authorities therein referred to, that evidence shall never be pleaded, for it only tends to prove matter of fact, and therefore the matter of fact shall be pleaded. Or, as the rule is sometimes stated, pleadings must not be argumentative. Stephen on pleading, 384, and authorities cited by him. In com. Dig. Pleader 3, and back. Abridgment. Please I, 5, and Stephen on place. Many decisions under this rule are collected. Introvert, for an indenture whereby a granted a manor, it is no plea that it did not grant a manor, for it does not answer the declaration except by argument. Yell. 223. So in trespass for taking and carrying away the plaintiff's goods, the defendant pleaded that the plaintiff never had any goods. The court said, this is an infallible argument that the defendant is not guilty, but it is no plea. Byard, a 43. In ejectment, the defendant pleaded the surrender of a capital by the hand of Fawcett, the steward. The plaintiff replied, that Fawcett was not steward. The court held this no issue, for it traversed the surrender only argumentatively. Crome. He liked, 260. In these cases, and many others reported in the books, the inferences from the facts stated were irresistible. But the court held they did not, when demurred to, amount to such inferable facts. In the case at bar, the inference that the defendant was a slave at the time of action brought, even if it can be made at all, from the fact that his parents were slaves, is certainly not the necessary inference. This case, therefore, is like that of Digby v. Alexander, 8 Bing, 116. In that case, the defendant pleaded many facts strongly tending to show that he was once Earl of Stirling, but as there was no positive allegation 60 U.S. 393, 571 that he was so at the time of action brought, and as every fact averred might be true, and yet the defendant not have been Earl of Stirling at the time of action brought, the plea was held to be insufficient. The lawful season of land is presumed to continue. But if, in an action of trespass quare clorthum, the defendant were to plead that he was lawfully seized of the locus in quote, 1 month before the time of the alleged trespass, I should have no doubt it would be a bad plea. See Mullen v. Torrance, 9 Wheat, 537. So if a plea to the jurisdiction, instead of alleging that the plaintiff was a citizen of the same state as the defendant, were to allege that the plaintiff's ancestors were citizens of that state, I think the plea could not be supported. My judgment would be, as it is in this case, that if the defendant meant to avert a particular substantive fact, as existing at the time of action brought, he must do it directly and explicitly, and not by way of inference from certain other averments, which are quite consistent with the contrary hypothesis. I cannot, therefore, treat this plea as containing an averment that the plaintiff himself was a slave at the time of action brought, and the inquiry recurs, whether the facts, that he is of African descent, and that his parents were once slaves, are necessarily inconsistent with his own citizenship. In the state of Missouri, within the meaning of the Constitution and laws of the United States. In Gassis v. Ballone, 6 Pet. 761, the defendant was described on the record as a naturalized citizen of the United States, residing in Louisiana. The court held this equivalent to an averment that the defendant was a citizen of Louisiana, because a citizen of the United States, residing in any state of the Union, is, for purposes of jurisdiction, a citizen of that state. Now, The plea to the jurisdiction in this case does not controvert the fact that the plaintiff resided in Missouri at the date of the writ. If he did then reside there, and was also a citizen of the United States, no provisions contained in the Constitution or laws of Missouri can deprive the plaintiff of his right to sue citizens of states other than Missouri, in the courts of the United States. So that, under the allegations contained in this plea, and admitted by the demurrer, the question is, whether any person of African descent, whose ancestors were sold as slaves in the United States, can be a citizen of the United States. If any such person can be a citizen, this plaintiff has the right to the judgment of the court that he is so, for no cause is shown by the plea why he is not so, except his descent and the slavery of his ancestors. The first section of the second article of the Constitution 60 U.S. 393, 572 uses the language, a citizen of the United States at the time of the adoption of the Constitution. One mode of approaching this question is to inquire who were citizens of the United States at the time of the adoption of the Constitution. Citizens of the United States at the time of the adoption of the Constitution can have been no other than citizens of the United States under the Confederation. By the Articles of Confederation, the government was organized. The style whereat was the United States of America. This government was in existence when the Constitution was framed and proposed for adoption, and was to be superseded by the new government of the United States of America, organized under the Constitution. When, therefore, the Constitution speaks of citizenship of the United States, existing at the time of the adoption of the Constitution, it must necessarily refer to citizenship under the government which existed prior to and at the time of such adoption. Without going into any question concerning the powers of the Confederation to govern the territory of the United States out of the limits of the states, and consequently to sustain the relation of government and citizen in respect to the inhabitants of such territory, it may safely be said that the citizens of the several states were citizens of the United States under the Confederation. That government was simply a confederacy of the several states, possessing a few defined powers over subjects of general concern, each state retaining every power, jurisdiction, and right, not expressly delegated to the United States in Congress assembled, and no power was thus delegated to the government of the Confederation, to act on any question of citizenship, or to make any rules in respect thereto. The whole matter was left to stand upon the action of the several states, and to the natural consequence of such action, that the citizens of each state should be citizens of that confederacy into which that state had entered. The style whereat was the United States of America. To determine whether any free persons, descended from Africans held in slavery, were citizens of the United States under the Confederation, and consequently at the time of the adoption of the Constitution of the United States, it is only necessary to know whether any such persons were citizens of either of the states under the Confederation, at the time of the adoption of the Constitution. Of this there can be no doubt. At the time of the ratification of the Articles of Confederation, all free native-born inhabitants of the states of New Hampshire, Massachusetts, New 60 U.S. 393, 573 York, New Jersey, and North Carolina, though descended from African slaves, were not only citizens of those states, but such of them as had the other necessary qualifications possessed a franchise of electors, on equal terms with other citizens. The Supreme Court of North Carolina, in the case of the State v. Manuel, for death and bat. 20, has declared the law of that state on this subject, in terms which I believe to be as sound law in the other states I have enumerated, as it was in North Carolina. According to the laws of this state, says Judge Gaston, in delivering the opinion of the court, all human beings within it, who are not slaves, fall within one of two classes. Whatever distinctions may have existed in the Roman laws between citizens and free inhabitants, they are unknown to our institutions. Before our Revolution, all free persons born within the dominions of the King of Great Britain, whatever their color or complexion, were native-born British subjects. Those born out of his allegiance were aliens. Slavery did not exist in England, but it did in the British colonies. Slaves were not in legal parlance persons, but property. The moment the incapacity, the disqualification of slavery, was removed, they became persons, and were then either British subjects, or not British subjects, according as they were or were not born within the allegiance of the British King. Upon the Revolution, no other change took place in the laws of North Carolina than was consequent on the transition from a colony dependent on a European king, to a free and sovereign state. Slaves remained slaves. British subjects in North Carolina became North Carolina freemen. Foreigners, until made members of the state, remained aliens. Slaves, manumitted here, became freemen, and therefore, if born within North Carolina, are citizens of North Carolina, and all free persons born within the state are born citizens of the state. The Constitution extended the elective franchise to every freeman who had arrived at the age of 21, and paid a public tax, and it is a matter of universal notoriety, that, under it, free persons, without regard to color, claimed and exercised the franchise, until it was taken from free men of color a few years since by our amended Constitution. In the state v. Newcomb, 5 Iredell 253, decided in 1844, the same court referred to this case of the state v. Manuel, and said, that case underwent a very laborious investigation, both by the bar and the bench. The case was brought here by appeal, and was felt to be one of great importance in principle. It was considered with an anxiety and care worthy of the principle involved, and which give it the controlling 60 U.S. 393, 574 influence and authority on all questions of a similar character. An argument from speculative premises, however well chosen, that the then state of opinion in the Commonwealth of Massachusetts was not consistent with the natural rights of people of color who were born on that soil, and that they were not, by the Constitution of 1780 of that state, admitted to the condition of citizens, would be received with surprise by the people of that state, who know their own political history. It is true, beyond all controversy, that persons of color, descended from African slaves, were by that Constitution made citizens of the state, and such of them as have had the necessary qualifications, have held and exercised the elective franchise, as citizens, from that time to the present. See Com. V. 18 Pick. R. 210. The Constitution of New Hampshire conferred the elective franchise upon every inhabitant of the state having the necessary qualifications, of which color or descent was not one. The Constitution of New York gave the right to vote to every male inhabitant, who shall have resided, and seized, making no discrimination between free colored persons and others. See Con. of N.Y., Art. 2, Red. Stats. of N.Y., Volume 1, page 126. That of New Jersey, to all inhabitants of this colony, of full age, who are worth 50 proclamation money, clear estate. New York, by its Constitution of 1820, required colored persons to have some qualifications as prerequisites for voting, which white persons need not possess. And New Jersey, by its present Constitution, restricts the right to vote to white male citizens. But these changes can have no other effect upon the present inquiry, except to show that before they were made, no such restrictions existed, and colored in common with white persons, were not only citizens of those states, but entitled to the elective franchise on the same qualifications as white persons, as they now are in New Hampshire and Massachusetts. I shall not enter into an examination of the existing opinions of that period respecting the African race, nor into any discussion concerning the meaning of those who asserted, in the Declaration of Independence, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. My own opinion is, that a calm comparison of these assertions of universal abstract truth, and their own individual opinions and acts, would not leave 60 U.S. 393, 575 these men under any reproach of inconsistency, that the great truths they asserted on that solemn occasion, they were ready and anxious to make effectual, wherever unnecessary regard to circumstances, which no statesman can disregard without producing more evil than good, would allow, and that it would not be just to them, nor true in itself, to allege that they intended to say that the Creator of all men had endowed the white race, exclusively, with the great natural rights which the Declaration of Independence asserts. But this is not the place of vindicate their memories. As I conceive, we should deal here, not with such disputes, if there can be a dispute concerning this subject, but with those substantial facts evinced by the written constitutions of states, and by the notorious practice under them. And they show, in a manner which no argument can obscure, that in some of the original 13 states, free colored persons, before and at the time of the formation of the Constitution, were citizens of those states. The fourth of the fundamental articles of the Confederation was as follows: the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice, excepted, shall be entitled to all the privileges and immunities of free citizens in the several states. The fact that free persons of color were citizens of some of the several states, and the consequence that this fourth article of the Confederation would have the effect to confer on such persons the privileges and immunities of general citizenship, were not only known to those who framed and adopted those articles, but the evidence is decisive that the fourth article was intended to have that effect, and that more restricted language, which would have excluded such persons, was deliberately and purposely rejected. On the 25th of June, 1778, the Articles of Confederation being under consideration by the Congress, the delegates from South Carolina moved to amend this fourth article, by inserting, after the word free, and before the word inhabitants, the word white, so that the privileges and immunities of general citizenship would be secured only to white persons. 2 states voted for the amendment, 8 states against it, and the vote of 1 state was divided. The language of the article stood unchanged, and both by its terms of inclusion, free inhabitants, and the strong implications from its terms of exclusion, paupers, vagabonds, and fugitives from justice, who alone were excepted, it is clear that under the Confederation, and at the time of the adoption of the Constitution, free colored persons of African descent might be, and, by reason of their citizenship in certain states, were entitled to the 60 U.S. 393, 576 privileges and immunities of general citizenship of the United States. Did the Constitution of the United States deprive them or their descendants of citizenship? That Constitution was ordained and established by the people of the United States, through the action, in each state, for those persons who were qualified by its laws to act their own, in behalf of themselves and all other citizens of that state. In some of the states, as we have seen, colored persons were among those qualified by law to act on this subject. These colored persons were not only included in the body of the people of the United States, by whom the Constitution was ordained and established, but in at least 5 of the states they had the power to act, and doubtless did act, by their suffrages, upon the question of its adoption. It would be strange, if we were to find in that instrument anything which deprived of their citizenship any part of the people of the United States who were among those by whom it was established. I can't find nothing in the Constitution which, proprio vigore, deprives of their citizenship any class of persons who were citizens of the United States at the time of its adoption, or who should be native-born citizens of any state after its adoption, nor any power enabling Congress to disfranchise persons born on the soil of any state, and entitled to citizenship of such state by its Constitution and laws. And my opinion is, that, under the Constitution of the United States, every free person born on the soil of a state, who is a citizen of that state by force of its Constitution or laws, is also a citizen of the United States. I will proceed to state the grounds of that opinion. The first section of the second article of the Constitution uses the language, "a natural-born citizen." It thus assumes that citizenship may be acquired by birth. Undoubtedly, this language of the Constitution was used in reference to that principle of public law, well understood in this country at the time of the adoption of the Constitution, which referred citizenship to the place of birth. At the Declaration of Independence, and ever since, the received general doctrine has been, in conformity with the common law, that free persons born within either of the colonies were subjects of the King, that by the Declaration of Independence, and the consequent acquisition of sovereignty by the several states, all such persons ceased to be subjects, and became citizens of the several states, except so far as some of them were disfranchised by the legislative power of the states, or availed themselves, seasonably, of the right to adhere to the British Crown in the civil contest, 60 U.S. 393, 577, and thus to continued British subjects. McIlvaine v. Cox's Lassie, 4 Cranch, 209, Inglis v. Sailors Nug Harbor, 3 Peters, page 99, Shanks v. DuPont, Hibbett, page 242. The Constitution having recognized the rule that persons born within the several states are citizens of the United States, one of 4 things must be true. First, that the Constitution itself has described what native-born persons shall or shall not be citizens of the United States, or, second, that it has empowered Congress to do so, or, Third, that all free persons, born within the several states, are citizens of the United States, or, fourth, that it is left to each state to determine what free persons, born within its limits, shall be citizens of such state, and thereby be citizens of the United States. If there be such a thing as citizenship of the United States acquired by birth within the states, which the Constitution expressly recognizes, and no one denies, then these four alternatives embrace the entire subject, and it only remains to select that one which is true. That the Constitution itself has defined citizenship of the United States by declaring what persons, born within the several states, shall or shall not be citizens of the United States, will not be pretended. It contains no such declaration. We may dismiss the first alternative, as without doubt unfounded. Has it empowered Congress to enact what free persons, born within the several states, shall or shall not be citizens of the United States? Before examining the various provisions of the Constitution which may relate to this question, it is important to consider for a moment the substantial nature of this inquiry. That is, in effect, whether the Constitution has empowered Congress to create privileged classes within the states, who alone can be entitled to the franchises and powers of citizenship of the United States. If it be admitted that the Constitution has enabled Congress to declare what free persons, born within the several states, shall be citizens of the United States, it must at the same time be admitted that it is an unlimited power. If this subject is within the control of Congress, it must depend wholly on its discretion. For, certainly, no limits of that discretion can be found in the Constitution, which is wholly silent concerning it, and the necessary consequence is, that the federal government may select classes of persons within the several states who alone can be entitled to the political privileges of citizenship of the United States. If this power exists, what persons born within the states may be president or vice president 60 U.S. 393, 578 of the United States, or members of either House of Congress, or hold any office or enjoy any privilege whereas citizenship of the United States is a necessary qualification, must depend solely on the will of Congress. By virtue of it, though Congress can grant no title of nobility, they may create an oligarchy, in whose hands would be concentrated the entire power of the federal government. It is a substantive power, distinct in its nature from all others, capable of affecting not only the relations of the state to the general government, but of controlling the political condition of the people of the United States. Certainly we ought to find this power granted by the Constitution, at least by some necessary inference, before we can say it does not remain to the state or the people. I proceed therefore to examine all the provisions of the Constitution which may have some bearing on this subject. Among the powers expressly granted to Congress is the power to establish a uniform rule of naturalization. It is not doubted that this is a power to prescribe the rule for the removal of the disabilities consequent on foreign birth. To hold that it extends further than this, would do violence to the meaning of the term naturalization, fixed in the common law, Company Lit. 8A, 129A, 2BS, Senator, 286, 2BL, Com. 293, and in the minds of those who concurred in framing and adopting the Constitution. It was in the sense of conferring on an alien and his issue the rights and powers of a native-born citizen, that it was employed in the Declaration of Independence. It was in this sense it was expounded in the Federalist, number 42, has been understood by Congress, by the judiciary, 2 wheat, 259, 269, 3 wash, R, 313, 322, 12 wheat, 277, and by commentators on the Constitution. 3 stories com. On con. 1 to 3, 1 raw on con. 84 to 88, 1 Tucker's BL. Com. APP 255259. It appears, then, that the only power expressly granted to Congress to legislate concerning citizenship is confined to the removal of the disabilities of foreign birth. Whether there be anything in the Constitution from which a broader power may be implied, will best be seen when we come to examine the 2 other alternatives, which are, whether all free persons, born on the soil of the several states, or only such of them as may be citizens of each state, respectively, are thereby citizens of the United States. The last of these alternatives, in my judgment, contains the truth. Undoubtedly, as has already been said, it is a principle of public law, recognized by the Constitution itself, that birth on the soil of a country both creates the beauty and confers the rights of citizenship. But it must be remembered, that though 60 U.S. 393, 579 the Constitution was to form a government, and under it the United States of America were to be one united sovereign nation, to which loyalty and obedience on the one side, and from which protection and privileges on the other, would be due, yet the several sovereign states, whose people were then citizens, were not only to continue in existence, but with powers unimpaired, except so far as they were granted by the people to the national government. Among the powers unquestionably possessed by the several states, was that of determining what persons should and what persons should not be citizens. It was practicable to confer on the government of the Union this entire power. It embraced what may, well enough for the purpose now in view, be divided into three parts. First, the power to remove the disabilities of alienage, either by special acts in reference to each individual case, or by establishing the rule of naturalization to be administered and applied by the courts. Second, determining what persons should enjoy the privileges of citizenship, in respect to the internal affairs of the several states. Third, what native-born persons should be citizens of the United States. The first named power, that of establishing the uniform rule of naturalization, was granted, and here the grant, according to its terms, stopped. Construing the Constitution containing only limited and defined powers of government, the argument derived from this definite and restricted power to establish the rule of naturalization, must be admitted to be exceedingly strong. I do not say it is necessarily decisive. It might be controlled by other parts of the Constitution. But when this particular subject of citizenship was under consideration, and, in the clause specially intended to define the extent of power concerning it, we find a particular part of this entire power separated from the residue, and conferred on the general government, there arises a strong presumption that this is all which is granted, and that the residue is left to the states and to the people. And this presumption is, in my opinion, converted into a certainty, by an examination of all such other clauses of the Constitution as touch this subject. It will examine each which can have any possible bearing on this question. The first clause of the second section of the third article of the Constitution is, the judicial power shall extend to controversies between the state and citizens of another state, between citizens of different states, between citizens of the same state, claiming lands under grants of different states, and between states, or the citizens thereof, and foreign states, 60 U.S. 393, 580 citizens, or subjects. I do not think this clause has any considerable bearing upon the particular inquiry now under consideration. Its purpose was to extend the judicial power to those controversies into which local feelings or interests might to enter as to disturb the course of justice, or give rise to suspicions that they had done so, and thus possibly give occasion to jealousy or ill will between different states, or a particular state and a foreign nation. At the same time, I would remark, in passing, that it has never been held, I do not know that it has ever been supposed, that any citizen of a state could bring himself under this clause and the 11th and 12th sections of the Judiciary Act of 1789, passed in pursuance of it, who was not a citizen of the United States. But I have referred to the clause, only because it is one of the places where citizenship is mentioned by the Constitution. Whether it is entitled to any weight in this inquiry or not, it refers only to citizenship of the several states. It recognizes that, but it does not recognize citizenship of the United States as something distinct therefrom. As has been said, the purpose of this clause did not necessarily connect it with citizenship of the United States, even if that were something distinct from citizenship of the several states, in the contemplation of the Constitution. This cannot be said of other clauses of the Constitution, which I now proceed to refer to. The citizens of each state shall be entitled to all the privileges and immunities of citizens of the several states. Nowhere else in the Constitution is there anything concerning the general citizenship, but here, privileges and immunities to be enjoyed throughout the United States, under and by force of the national compact, are granted and secured. In selecting those who are to enjoy these national rights of citizenship, how are they described? As citizens of each state. It is to them these national rights are secured. The qualification for them is not to be looked for in any provision of the Constitution or laws of the United States. They are to be citizens of the several states, and, as such, the privileges and immunities of general citizenship, derived from and guaranteed by the Constitution, are to be enjoyed by them. It would seem that if it had been intended to constitute a class of native-born persons within the states, who should derive their citizenship of the United States from the action of the federal government, this was an occasion for referring to them. It cannot be supposed that it was a purpose of this article to confer the privileges and immunities of citizens in all the states upon persons not citizens of the United States. 60 U.S. 393, 581. And if it was intended to secure these rights only to citizens of the United States, how has the Constitution here described such persons? Simply as citizens of each state. But, further, though, as I shall presently more fully state, I do not think the enjoyment of the elective franchise essential to citizenship. There can be no doubt it is one of the chiefest attributes of citizenship under the American constitutions, and the just and constitutional possession of this right is decisive evidence of citizenship. The provisions made by a constitution on this subject must therefore be looked to as bearing directly on the question what persons are citizens under that constitution, and as being decisive, to this extent, that all such persons as are allowed by the Constitution to exercise the elective franchise, and thus to participate in the government of the United States, must be deemed citizens of the United States. Here, again, the consideration presses itself upon us, that if there was designed to be a particular class of native-born persons within the states, deriving their citizenship from the Constitution and laws of the United States, they should at least have been referred to as those by whom the President and House of Representatives were to be elected, and to whom they should be responsible. Instead of that, we again find this subject referred to the laws of the several states. The electors of President are to be appointed in such manner as the legislature of each state may direct, and the qualifications of electors of members of the House of Representatives shall be the same as for electors of the most numerous branch of the state legislature. Laying aside, then, the case of aliens, concerning which the Constitution of the United States has provided, and confining our view to free persons born within the several states, we find that the Constitution has recognized the general principle of public law, that allegiance and citizenship depend on the place of birth, that it has not attempted practically to apply this principle by designating the particular classes of persons who should or should not come under it, that when we turn to the Constitution for an answer to the question, what free persons, born within the several states, are citizens of the United States, the only answer we can receive from any of its express provisions is, the citizens of the several states are to enjoy the privileges and immunities of citizens in every state, and their franchise as electors under the Constitution depends on their citizenship in the several states. Add to this, that the Constitution was ordained by the citizens of the several states, that they were the people of the United States, for whom 60 U.S. 393, 582 and whose posterity the government was declared in the preamble of the Constitution to be made, that each of them was a citizen of the United States at the time of the adoption of the Constitution, within the meaning of those words in that instrument, they by them the government was to be and was in fact organized, and that no power is conferred on the government of the Union to discriminate between them, or to disfranchise any of them. The necessary conclusion is, that those persons born within the several states, who, by force of their respective constitutions and laws, are citizens of the state, are thereby citizens of the United States. It may be proper here to notice some supposed objection to this vise of the subject. It has been often asserted that the Constitution was made exclusively by and for the white race. It has already been shown that in 5 of the 13 original states, colored persons then possessed the elective franchise, and were among those by whom the Constitution was ordained and established. If so, it is not true, in point of fact, that the Constitution was made exclusively by the white race, and that it was made exclusively for the white race is, in my opinion, not only an assumption not warranted by anything in the Constitution, but contradicted by its opening declaration, that it was ordained and established by the people of the United States, for themselves and their posterity. And as free colored persons were then citizens of at least 5 states, and so in every sense part of the people of the United States, they were among those for whom and whose posterity the Constitution was ordained and established. Again, it has been objected, that if the Constitution has left to the several states the rightful power to determine who of their inhabitants shall be citizens of the United States, the states may make aliens citizens. The answer is obvious. The Constitution has left to the states the determination what persons, born within their respective limits, shall acquire by birth citizenship of the United States, it has not left to them any power to prescribe any rule for the removal of the disabilities of alienage. This power is exclusively in Congress. It has been further objected that if free colored persons, born within a particular state, and made citizens of that state by its Constitution and laws, are thereby made citizens of the United States, then, under the second section of the fourth article of the Constitution, such persons would be entitled to all the privileges and immunities of citizens in the several states, and if so, then colored persons could vote, and be 60 U.S. 393, 583 eligible to not only federal offices, but offices even in those states whose constitution and laws disqualify colored persons from voting or being elected to office. But this position rests upon an assumption which I deem untenable. Its basis is that no one can be deemed a citizen of the United States who is not entitled to enjoy all the privileges and franchises which are conferred on any citizen. See 1 Lit. Kentucky R. 326. That this is not true, under the Constitution of the United States, seems to me clear. A naturalized citizen cannot be President of the United States, nor a senator till after the lapse of 9 years, nor a representative till after the lapse of 7 years, from his naturalization. Yet, as soon as naturalized, he is certainly a citizen of the United States. Nor is any inhabitant of the District of Columbia, or of either of the territories, eligible to the office of senator or representative in Congress, though they may be citizens of the United States. So, in all the states, numerous persons, though citizens, cannot vote, or cannot hold office, either on account of their age, or sex, or the want of the necessary legal qualifications. The truth is, that citizenship, under the Constitution of the United States, is not dependent on the possession of any particular political or even of all civil rights, and any attempt so to define it must lead to error. To what citizens the elective franchise shall be confided, is a question to be determined by each state, in accordance with its own views of the necessities or expediencies of its condition. What civil rights shall be enjoyed by its citizens, and whether all shall enjoy the same, or how they may be gained or lost, are to be determined in the same way. One may confine the right of suffrage to white male citizens, another may extend it to colored persons and females, one may allow all persons above a prescribed age to convey property and transact business, another may exclude married women. But whether native-born women, or persons under age, or under guardianship because insane or spendthrifts, be excluded from voting or holding office, or allowed to do so, I apprehend no one will deny that they are citizens of the United States. Besides, this clause of the Constitution does not confer on the citizens of one state, in all other states, specific and enumerated privileges and immunities. They are entitled to such as belong to citizenship, but not to such as belong to particular citizens attended by other qualifications. Privileges and immunities which belong to certain citizens of a state, by reason of the operation of causes other than mere citizenship, are not conferred. Thus, if the laws of a state require, in addition to 60 U.S. 393, 584 citizenship of the state, some qualification for office, or the exercise of the elective franchise, citizens of all other states, coming thither to reside, and not possessing those qualifications, cannot enjoy those privileges, not because they are not to be deemed entitled to the privileges of citizens of the state in which they reside, but because they, in common with the native-born citizens of that state, must have the qualifications prescribed by law for the enjoyment of such privileges, under its Constitution and laws. It rests with the states themselves so to frame their constitutions and laws as not to attach a particular privilege or immunity to mere naked citizenship. If one of the states will not deny to any of its own citizens a particular privilege or immunity, if it confer it on all of them by reason of mere naked citizenship, then it may be claimed by every citizen of each state by force of the Constitution, and it must be borne in mind that the difficulties which attend the allowance of the claims of colored persons to be citizens of the United States are not avoided by saying that, though each state may make them its citizens, they are not thereby made citizens of the United States. Because the privileges of general citizenship are secured to the citizens of each state. The language of the Constitution is, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. If each state may make such persons its citizens, they became, as such, entitled to the benefits of this article, if there be a native-born citizenship of the United States distinct from a native-born citizenship of the several states. There is one view of this article entitled to consideration in this connection. It is manifestly copied from the fourth of the Articles of Confederation, with only slight changes of phraseology, which render its meaning more precise, and dropping the clause which excluded paupers, vagabonds, and fugitives from justice, probably because these cases could be dealt with under the police powers of the states, and a special provision therefore was not necessary. It has been suggested that in adopting it into the Constitution, the words free inhabitants were changed for the word citizens. An examination of the forms of expression commonly used in the state papers of that day, and an attention to the substance of this article of the Confederation, will show that the words free inhabitants, as then used, were synonymous with citizens. When the Articles of Confederation were adopted, we were in the midst of the War of the Revolution, and there were very few persons then embraced in the words free inhabitants, who were not born on our soil. It was not the time when many, save the 60 U.S. 393, 585 children of the soil, were willing to embark their fortunes in our cause, and though there might be an inaccuracy in the uses of words to call free inhabitants citizens, it was then a technical rather than a substantial difference. If we look into the constitutions and state papers of that period, we find the inhabitants or people of these colonies, or the inhabitants of this state, or commonwealth, employed to designate those whom we should now denominate citizens. The substance and purpose of the article prove it was in this sense it used these words. It secured to the free inhabitants of each state the privileges and immunities of free citizens in every state. It is not conceivable that the states should have agreed to extend the privileges of citizenship to persons not entitled to enjoy the privileges of citizens in the states where they dwelt, that under this article there was a class of persons in some of the states, not citizens, to whom were secured all the privileges and immunities of citizens when they went into other states, and the just conclusion is, that though the Constitution cured an inaccuracy of language, it left the substance of this article in the National Constitution the same as it was in the Articles of Confederation. The history of this fourth article, respecting the attempt to exclude free persons of color from its operation, has been already stated. It is reasonable to conclude that this history was known to those who framed and adopted the Constitution, that under this fourth article of the Confederation, free persons of color might be entitled to the privileges of general citizenship, if otherwise entitled thereto, is clear. When this article was, in substance, placed in and made part of the Constitution of the United States, with no change in its language calculated to exclude free colored persons from the benefit of its provisions, the presumption is, to say the least, strong, that the practical effect which it was designed to have, and did have, under the former government, it was designed to have, and should have, under the new government. It may be further objected, that if free colored persons may be citizens of the United States, it depends only on the will of the master whether he will emancipate his slave, and thereby make him a citizen. Not so. The master is subject to the will of the state. Whether he shall be allowed to emancipate his slave at all, if so, on what conditions, and what is to be the political status of the freed man, depend, not on the will of the master, but on the will of the state, upon which the political status of all its native-born inhabitants depends. Under the Constitution of the United States, each state has retained this power of determining the political status of its native-born 60 U.S. 393, 586 inhabitants, and no exception thereto can be found in the Constitution. And if a master in a slave-holding state should carry his slave into a free state, and there emancipate him, he would not thereby make him a native-born citizen of that state, and consequently no privileges could be claimed by such emancipated slave as a citizen of the United States. For, whatever powers the states may exercise to confer privileges of citizenship on persons not born on their soil, the Constitution of the United States does not recognize such citizens. As has already been said, it recognizes the great principle of public law, that allegiance and citizenship spring from the place of birth. It leaves to the states the application of that principle to individual cases. It secured to the citizens of each state the privileges and immunities of citizens in every other state. But it does not allow to the states the power to make alien citizens, or permit one state to take persons born on the soil of another state, and, contrary to the laws and policy of the state where they were born, make them its citizens, and so citizens of the United States. No such deviation from the great rule of public law was contemplated by the Constitution, and when any such attempt shall be actually made, it is to be met by applying to it those rules of law and those principles of good faith which will be sufficient to decide it, and not, in my judgment, by denying that all the free native-born inhabitants of a state, who are its citizens under its Constitution and laws, are also citizens of the United States. It has sometimes been urged that colored persons are shown not to be citizens of the United States by the fact that the naturalization laws apply only to white persons. But whether a person born in the United States be or be not a citizen, cannot depend on laws which refer only to aliens, and do not affect the status of persons born in the United States. The utmost effect which can be attributed to them is to show that Congress has not deemed it expedient generally to apply the rule to colored aliens. That they might do so, if those fit, is clear. The Constitution has not excluded them. And since that has conferred the power on Congress to naturalize colored aliens, it certainly shows color is not the necessary qualification for citizenship under the Constitution of the United States. It may be added, that the power to make colored persons citizens of the United States, under the Constitution, has been actually exercised in repeated and important instances. See the treaties with the Choctaws, of September 27, 1830, Part 14, with the Cherokees, of May 23, 1836, Part 12, Treaty of Guadalupe Hidalgo, February 2, 1848, Part 8. I do not deem it necessary to review at length the legislation 60 U.S. 393, 587 of Congress having more or less bearing on the citizenship of colored persons. It does not seem to me to have any considerable tendency to prove that it has been considered by the legislative department of the government, that no such persons are citizens of the United States. Undoubtedly they have been debarred from the exercise of particular rights or privileges extended to white persons, but, I believe, always in terms which, by implication, admit they may be citizens. Thus the Act of May 17, 1792, for the organization of the militia, directs the enrollment of every free, able-bodied, white male citizen. An assumption that none but white persons are citizens would be as inconsistent with the just import of this language, as that all citizens are able-bodied, or males. So the Act of February 28, 1803, to state, at large, 205, to prevent the importation of certain persons into states, when by the laws thereof their admission is prohibited, in its first section forbids all masters of vessels to import or bring any Negro, mulatto, or other person of color, not being a native, a citizen, or registered seaman of the United States, and c. The Acts of March 3, 1813, Section 1, to state, at large, 809, and March 1, 1817, Section 3, 3 stat, at large, 351, concerning seamen, certainly imply there may be persons of color, natives of the United States, who are not citizens of the United States. This implication is undoubtedly in accordance with the fact, for not only slaves, but free persons of color, born in some of the states, are not citizens. But there is nothing in these laws inconsistent with the citizenship of persons of color in others of the states, nor with their being citizens of the United States. Whether much or little weight should be attached to the particular phraseology of these and other laws, which were not passed with any direct reference to this subject, I consider their tendency to be, as already indicated, to show that, in the apprehension of their framers, color was not a necessary qualification of citizenship. It would be strange, if laws were found on our statute book to that effect, when, by solemn treaties, large bodies of Mexican and North American Indians as well as free colored inhabitants of Louisiana have been admitted to citizenship of the United States. In the legislative debate which preceded the admission of the state of Missouri into the Union, this question was agitated. Its result is found in the resolution of Congress, of March 5, 1821, for the admission of that state into the Union. The Constitution of Missouri, under which that state applied for admission into the Union, provided that it should be the duty 60 U.S. 393, 588 of the legislature to pass laws to prevent free Negroes and mulattoes from coming to and settling in the state, under any pretext whatever. One ground of objection to the admission of the state under this Constitution was that it would require the legislature to exclude free persons of color, who would be entitled, under the second section of the fourth article of the Constitution, not only to come within the state, but to enjoy there the privileges and immunities of citizens. The resolution of Congress admitting the state was upon the fundamental condition that the Constitution of Missouri shall never be construed to authorize the passage of any law, and that no law shall be passed in conformity thereto, by which any citizen of either of the states of this Union shall be excluded from the enjoyment of any of the privileges and immunities to which such citizen is entitled under the Constitution of the United States. It is true that neither this legislative declaration, nor anything in the Constitution or laws of Missouri, could confer or take away any privilege or immunity granted by the Constitution. But it is also true that it expresses the then conviction of the legislative power of the United States, that free Negroes, as citizens of some of the states, might be entitled to the privileges and immunities of citizens in all the states. The conclusions at which I have arrived on this part of the case are, first, that the free native-born citizens of each state are citizens of the United States. Second, that as free colored persons born within some of the states are citizens of those states, such persons are also citizens of the United States. Third, that every such citizen, residing in any state, has the right to sue and is liable to be sued in the federal courts, as a citizen of that state in which he resides. Fourth, that as the plea to the jurisdiction in this case shows no facts, except that the plaintiff was of African descent, and his ancestors were sold as slaves, and as these facts are not inconsistent with his citizenship of the United States, and his residence in the state of Missouri, the plea to the jurisdiction was bad, and the judgment of the circuit court overruling it was correct. I dissent, therefore, from that part of the opinion of the majority of the court, in which it is held that a person of African descent cannot be a citizen of the United States, and I regret I must go further, and dissent both from what I deem their assumption of authority to examine the constitutionality of the Act of Congress commonly called the Missouri Compromise 60 U.S. 393, 589 Act, and the grounds and conclusions announced in their opinion. Having first decided that they were bound to consider the sufficiency of the plea to the jurisdiction of the circuit court, and having decided that this plea showed that the circuit court had not jurisdiction, and consequently that this is a case to which the judicial power of the United States does not extend, they have gone on to examine the merits of the case as they appeared on the trial before the court and jury, on the issues joined on the pleas in bar, and so have reached the question of the power of Congress to pass the Act of 1820. On so grave a subject as this, I feel obliged to say that, in my opinion, such an exertion of judicial power transcends the limits of the authority of the court, as described by its repeated decisions, and, as I understand, acknowledged in this opinion of the majority of the court. In the course of that opinion, it became necessary to comment on the case of LeGrand v. Darnall, reported in Peters R. 664. In that case, the bill was filed by one alleged to be a citizen of Maryland, against one alleged to be a citizen of Pennsylvania. The bill stated that the defendant was the son of a white man by one of his slaves, and that the defendant's father devised to him certain lands, the title to which was put in controversy by the bill. These facts were omitted in the answer, and upon these and other facts the court made its decree, founded on the principle that a devise of land by a master to a slave was by implication also a bequest of his freedom. The facts that the defendant was of African descent, and was born a slave, were not only before the court, but entered into the entire substance of its inquiries. The opinion of the majority of my brethren in this case disposes of the case of LeGrand v. Darnall, by saying, among other things, that as the fact that the defendant was born a slave only came before this court on the bill and answer, it was then too late to raise the question of the personal disability of the party, and therefore that decision is altogether inapplicable in this case. In this I concur. Since the decision of this court in Livingston v. Story, 11 Pet. 351, the law has been settled, that when the declaration or bill contains the necessary averments of citizenship, this court cannot look at the record to see whether those averments are true, except so far as they are put in issue by a plea to the jurisdiction. In that case, the defendant denied by his answer that Mr. Livingston was a citizen of New York, as he had alleged in the bill. Both parties went into proofs. the court refused to examine those proofs, with reference to the personal disability of the plaintiff. This is the 60 U.S. 393, 590 settled law of the court, affirmed so lately as Shepherd v. Grates, 14 Hout, 27, and Wycliffe v. Owings, 17 Hout, 51. See also D. Wool v. Rudbot, 1 Pet, 476. But I do not understand this to be a rule which the court may depart from of its pleasure. If it be a rule, it is as binding on the court as on the suitors. If it removed from the latter the power to take any objection to the personal disability of a party alleged by the record to be competent, which is not shown by a plea to the jurisdiction, it is because the court are forbidden by law to consider and decide on objections so taken. I do not consider it to be within the scope of the judicial power of the majority of the court to pass upon any question respecting the plaintiff's citizenship in Missouri, save that raised by the plea to the jurisdiction, and I do not hold any opinion of this court. For any court, binding, when expressed on a question not legitimately before it. Carroll v. Carroll, 16 Hout, 275. The judgment of this court is, that the case is to be dismissed for want of jurisdiction, because the plaintiff was not a citizen of Missouri, as he alleged in his declaration. Into that judgment, according to the settled course of this court, nothing appearing after a plea to the merits can enter. The great question of constitutional law, deeply affecting the peace and welfare of the country, is not, in my opinion, the fit subject to be thus reached. But as, in my opinion, the circuit court had jurisdiction, I am obliged to consider the question whether its judgment on the merits of the case should stand or be reversed. The residence of the plaintiff in the state of Illinois, and the residence of himself and his wife in the territory acquired from France lying north of latitude 36 degrees 30 minutes, and north of the state of Missouri, are each relied on by the plaintiff in error. As the residence in the territory affects the plaintiff's wife and children as well as himself, I must inquire what was its effect. The general question may be stated to be, whether the plaintiff's status, as a slave, was so changed by his residence within that territory, that he was not a slave in the state of Missouri, at the time this action was brought. In such cases, two inquiries arise, which may be confounded, but should be kept distinct. The first is, what was the law of the territory into which the master and slave went, respecting the relation between them? The second is, whether the state of Missouri recognizes and allows the effect of that law of the territory, on the status of the slave, on his return within its jurisdiction. As to the first of these questions, the will of states and nations, 60 U.S. 393, 591, by whose municipal law slavery is not recognized, has been manifested in three different ways. One is, absolutely to dissolve the relation, and terminate the rights of the master existing under the law of the country whence the parties came. This is said by Lord Stowell, in the case of the slave Grace, to have 80 R. 94, and by the Supreme Court of Louisiana in the case of Maria Louise v. Morrow, 9 Lewis, R. 473, to be the law of France, and it has been the law of several states of this Union, in respect to slaves introduced under certain conditions. Wilson v. Isabel, 5 Calls R. 430, Hunter v. Halter, 1 Lee, 172, Stewart v. Oaks, 5 Hart, and John, 107. The second is, where the municipal law of a country not recognizing slavery, it is the will of the state to refuse the master all aid to exercise any control over his slave, and if he attempt to do so, in a manner justifiable only by that relation, to prevent the exercise of that control. But no law exists, designed to operate directly on the relation of master and slave, and put an end to that relation. This is said by Lord Stowell, in the case above mentioned, to be the law of England, and by Mr. Chief Justice Shaw, in the case of the Commonwealth v. Aves, 18 Pick, 193, to be the law of Massachusetts. The third is, to make a distinction between the case of the master and his slave only temporarily in the country, on a motu non monendi, and those who are there to reside for permanent or indefinite purposes. This is said by Mr. Wheaton to be the law of Prussia, and was formerly the statute law of several states of our Union. It is necessary in this case to keep in view this distinction between those countries whose laws are designed to act directly on the status of a slave, and make him a freeman, and those where his master can obtain no aid from the laws to enforce his rights. It is to the last case only that the authorities, out of Missouri, relied on by defendant, apply, when the residence in the non-slave holding territory was permanent. In the Commonwealth v. Aves, 18 Pick. 218, Mr. Chief Justice Shaw said, from the principle above stated, on which a slave brought here becomes free, to wit, that he becomes entitled to the protection of our laws, it would seem to follow, as a necessary conclusion, that if the slave waives the protection of those laws, and returns to the state where he is held as a slave, his condition is not changed. It was upon this ground, as is apparent from his whole reasoning, that Sir William Scott rests his opinion in the case of the slave Grace. To use one of his expressions, the effect of the law of England was to put the liberty of the slave into a parenthesis. If there had been an 16 U.S. 393, 592 Act of Parliament declaring that a slave coming to England with his master should thereby be deemed no longer to be a slave, it is easy to see that the learned judge could not have arrived at the same conclusion. This distinction is very clearly stated and shown by President Tucker, in his opinion in the case of Betty v. Horton, 5 Lees, Virginia Bar, 615. See also Hunter v. Fletcher, 1 Lees v. 8, Har, 172, Maria Louise v. Morrow, 9 Louisiana Bar, Smith v. Smith, 13 IB, 441, Thomas v. Genevieve, 16 IB, 483, Rankin v. Lydia, 2 A.K. Marshall, 467, Davies v. Tingle, 8 Beeman Road, 539, Griffith v. Fanny, Jome v. 8, Har, 143, Lumford v. Coquitlam, 14 Martin's Lawn, Har, 405, Josephine v. Pulteney, 1 Lewis, and Har, 329. But if the acts of Congress on this subject are valid, the law of the territory of Wisconsin, within whose limits the residence of the plaintiff and his wife, and their marriage and the birth of one or both of their children, took place, falls under the first category, and is a law operating directly on the status of the slave. By the 8th section of the Act of March 6, 1820, 3 Stat. At large, 548, it was enacted that, within this territory, slavery and involuntary servitude, otherwise than in the punishment of crimes, whereof the parties shall have been duly convicted, shall be, and is hereby, forever prohibited, provided, always, that any person escaping into the same, from whom labor or service is lawfully claimed in any state or territory of the United States, such fugitive may be lawfully reclaimed, and conveyed to the person claiming his or her labor or service, as aforesaid. By the Act of April 20, 1836, for Stat. At large, 10, passed in the same month and year of the removal of the plaintiff to Fort Snelling, this part of the territory ceded by France, where Fort Snelling is, together with so much of the territory of the United States east of the Mississippi as now constitutes the state of Wisconsin, was brought under a territorial government, under the name of the Territory of Wisconsin. By the 18th section of this act, it was enacted, that the inhabitants of this territory shall be entitled to and enjoy all and singular the rights, privileges, and advantages, granted and secured to the people of the territory of the United States northwest of the river Ohio, by the Articles of Compact contained in the ordinance for the government of said territory, passed on the 13th day of July, 1787, and shall be subject to all the restrictions and prohibitions in said Articles of Compact imposed upon the people of the said territory. The 6th article of that compact is, there shall be neither slavery nor involuntary servitude in the said territory, otherwise than in 16 U.S. 393, 593 the punishment of crimes, whereof the party shall have been duly convicted. Provided, always, that any person escaping into the same, from whom labor or service is lawfully claimed in any one of the original states, such fugitive may be lawfully reclaimed, and conveyed to the person claiming his or her labor or service, as aforesaid. By other provisions of this act establishing the territory of Wisconsin, the laws of the United States, and the then existing laws of the state of Michigan, are extended over the territory, the latter being subject to alteration and repeal by the legislative power of the territory created by the Act. Fort Snelling was within the territory of Wisconsin, and these laws were extended over it. The Indian title to that site for a military post had been acquired from the Sioux Nation as early as September 23, 1805, M. State Papers, Indian Affairs, Volume 1, page 744. and until the erection of the territorial government, the persons at that post were governed by the rules and articles of war, and such laws of the United States, including the 8th section of the Act of March 6, 1820, prohibiting slavery, as were applicable to their condition. But after the erection of the territory, and the extension of the laws of the United States and the laws of Michigan over the whole of the territory, including this military post, the persons residing there were under the dominion of those laws in all particulars to which the rules and articles of war did not apply. It thus appears that, by these acts of Congress, not only was a general system of municipal law borrowed from the state of Michigan, which did not tolerate slavery, but it was positively enacted that slavery and involuntary servitude, with only one exception, specifically described, should not exist there. It is not simply that slavery is not recognized and cannot be aided by the municipal law. It is recognized for the purpose of being absolutely prohibited, and declared incapable of existing within the territory, save in the instance of a fugitive slave. It would not be easy for the legislature to employ more explicit language to signify its will that the status of slavery should not exist within the territory, than the words found in the Act of 1820, and in the Ordinance of 1787, and if any doubt could exist concerning their application to cases of masters coming into the territory with their slaves to reside, that doubt must yield to the inference required by the words of exception. That exception is, of cases of fugitive slaves. An exception from a prohibition marks the extent of the prohibition, for it would be absurd, as well as useless, to accept from a prohibition 60 U.S. 393, 594 a case not contained within it. 9 wheat, 200. I must conclude, therefore, that it was the will of Congress that the state of involuntary servitude of a slave, coming into the territory with his master, should cease to exist. The Supreme Court of Missouri so held in Rachel v. Walker, forma zone R. 350, which was a case of a military officer going into the territory with 2 slaves. But it is a distinct question, whether the law of Missouri recognized and allowed effect to the change wrought in the status of the plaintiff, by force of the laws of the territory of Wisconsin. I say the law of Missouri, because a judicial tribunal, in one state or nation, can recognize personal rights acquired by force of the law of any other state or nation, only so far as it is the law of the former state that those rights should be recognized. But, in the absence of positive law to the contrary, the will of every civilized state must be presumed to be to allow such effect to foreign laws as if in accordance with the settled rules of international law, and legal tribunals are bound to act on this presumption. It may be assumed that the motive of the state in allowing such operation to foreign laws is what has been termed comity. But, as has justly been said, per Chief Justice Taney, 13 Pet. 589, it is the comity of the state, not of the court. The judges have nothing to do with the motive of the state. Their duty is simply to ascertain and give effect to its will. And when it is found by them that its will to depart from a rule of international law has not been manifested by the state, they are bound to assume that its will is to give effect to it. Undoubtedly, every sovereign state may refuse to recognize a change, wrought by the law of a foreign state, on the status of a person, while within such foreign state, even in cases where the rules of international law require that recognition. Its will to refuse such recognition may be manifested by what we term statute law, or by the customary law of the state. It is within the province of its judicial tribunals to inquire and adjudge whether it appears, from the statute or customary law of the state, to be the will of the state to refuse to recognize such changes of status by force of foreign law, as the rules of the law of nations require to be recognized. But, in my opinion, it is not within the province of any judicial tribunal to refuse such recognition from any political considerations, or any view it may take of the exterior political relations between the state and one or more foreign states, or any impressions it may have that a change of foreign opinion and action on the subject of slavery may afford a reason why the state should change its own action. To understand and give 60 U.S. 393, 595 just effect to such considerations, and to change the action of the state in consequence of them, are functions of diplomatists and legislators, not of judges. The inquiry to be made on this part of the case is, therefore, whether the state of Missouri has, by its statute, or its customary laws, manifested its will to displace any rule of international law, applicable to a change of the status of a slave, by foreign law. I have not heard it suggested that there was any statute of the state of Missouri bearing on this question. The customary law of Missouri is the common law, introduced by statute in 1816. 1 term. Laws, 436. And the common law, as Blackstone says, for com. 67, adopts, in its full extent, the law of nations, and holds it to be a part of the law of the land. I know of no sufficient warrant for declaring that any rule of international law, concerning the recognition, in that state, of a change of status, brought by an extraterritorial law, has been displaced or varied by the will of the state of Missouri. I proceed then to inquire what the rules of international law prescribe concerning the change of status of the plaintiff brought by the law of the territory of Wisconsin. It is generally agreed by writers upon international law, and the rule has been judicially applied in a great number of cases, that wherever any question may arise concerning the status of a person, it must be determined according to that law which has next previously rightfully operated on and fixed that status. And, further, that the laws of a country do not rightfully operate upon and fix the status of persons who are within its limits in itinerant, or who are abiding there for definite temporary purposes, as for health, curiosity, or occasional business, that these laws, known to writers on public and private international law as personal statutes, operate only on the inhabitants of the country. Not that it is or can be denied that each independent nation may, if it thinks fit, apply them to all persons within their limits. But when this is done, not in conformity with the principles of international law, other states are not understood to be willing to recognize or allow effect to such applications of personal statutes. It becomes necessary, therefore, to inquire whether the operation of the laws of the territory of Wisconsin upon the status of the plaintiff was or was not such an operation as these principles of international law require other states to recognize and allow effect to. And this renders it needful to attend to the particular facts and circumstances of this case. 60 U.S. 393, 596. It appears that this case came on for trial before the circuit court and a jury, upon an issue, in substance, whether the plaintiff, together with his wife and children, were the slaves of the defendant. The court instructed the jury that, upon the facts in this case, the law is with the defendant. This withdrew from the jury the consideration and decision of every matter of fact. The evidence in the case consisted of written admissions, signed by the counsel of the parties. If the case had been submitted to the judgment of the court, upon an agreed statement of facts, entered of record, in place of a special verdict, it would have been necessary for the court below, and for this court, to pronounce its judgment solely on those facts, thus agreed, without inferring any other facts therefrom. By the rules of the common law applicable to such a case, and by force of the 7th article of the amendments of the Constitution, this court is precluded from finding any fact not agreed to by the parties on the record. No submission to the court on a statement of facts was made. It was a trial by jury, in which certain admissions, made by the parties, were the evidence. The jury were not only competent, but were bound to draw from that evidence every inference which, in their judgment, exercised according to the rules of law, it would warrant. The circuit court took from the jury the power to draw any inferences from the admissions made by the parties, and decided the case for the defendant. This course can be justified here, if at all, only by its appearing that upon the facts agreed, and all such inferences of fact favorable to the plaintiff's case, as the jury might have been warranted in drawing from those admissions, the law was with the defendant. Otherwise, the plaintiff would be deprived of the benefit of his trial by jury, by whom, for aught we can know, those inferences favorable to his case would have been drawn. The material facts agreed, bearing on this part of the case, are, that Dr. Emerson, the plaintiff's master, resided about 2 years at the military post of Fort Snelling, being a surgeon in the Army of the United States, his domicile of origin being unknown, and what, if anything, he had done to preserve or change his domicile prior to his residence at Rock Island, being also unknown. Now, it is true that under some circumstances the residence of a military officer at a particular place, in the discharge of his official duties, does not amount to the acquisition of a technical domicile, but it cannot be affirmed, with correctness, that it never does. There being actual residence, and this being presumptive evidence of domicile, all the circumstances 60 U.S. 393, 597 of the case must be considered, before a legal conclusion can be reached, that his place of residence is not his domicile. If a military officer stationed at a particular post should entertain an expectation that his residence there would be indefinitely protracted, and in consequence should remove his family to the place where his duties were to be discharged, form a permanent domestic establishment there, exercise there the civil rights and discharge the civil duties of an inhabitant, while he did not act and manifested no intent to have a domicile elsewhere, I think no one would say that the mere fact that he was himself liable to be called away by the orders of the government would prevent his acquisition of a technical domicile at the place of the residence of himself and his family. In other words, I do not think a military officer incapable of acquiring the domicile. Bruce v. Bruce, 2 Boss and Poole, 230, Monroe v. Douglas, 5 Mad. Chapter Art, 232. This being so, this case stands thus. There was evidence before the jury that Emerson resided about 2 years at Fort Snelling, in the territory of Wisconsin. This may or may not have been with such intent as to make it his technical domicile. The presumption is that it was. It is so laid down by this court, in Ennis v. Smith, 14 How, and the authorities in support of the position are there referred to. His intent was a question of fact for the jury. Fitchburg v. Winchendon, for Cook, 190. The case was taken from the jury. If they had power to find that the presumption of the necessary intent had not been rebutted, we cannot say, on this record, that Emerson had not his technical domicile at Fort Snelling. But, for reasons which I shall now proceed to give, I do not deem it necessary in this case to determine the question of the technical domicile of Dr. Emerson. It must be admitted that the inquiry whether the law of a particular country has rightfully fixed the status of a person, so that in accordance with the principles of international law its status should be recognized in other jurisdictions, ordinarily depends on the question whether the person was domiciled in the country whose laws are asserted to have fixed his status. But, in the United States, questions of this kind may arise, where an attempt to decide solely with reference to technical domicile, tested by the rules which are applicable to changes of places of abode from one country to another, would not be consistent with sound principles. And, in my judgment, this is one of those cases. The residence of the plaintiff, who was taken by his master, Dr. Emerson, as a slave, from Missouri to the state of Illinois, and thence to the territory of Wisconsin, must be deemed to 60 U.S. 393, 598 have been for the time being, and until he asserted his own separate intention, the same as the residence of his master, and the inquiry, whether the personal statutes of the territory were rightfully extended over the plaintiff, and ought, in accordance with the rules of international law, to be allowed to fix his status, must depend upon the circumstances under which Dr. Emerson went into that territory, and remained there, and upon the further question, whether anything was there rightfully done by the plaintiff to cause those personal statutes to operate on him. Dr. Emerson was an officer in the Army of the United States. He went into the territory to discharge his duty to the United States. The place was out of the jurisdiction of any particular state, and within the exclusive jurisdiction of the United States. It does not appear where the domicile of origin of Dr. Emerson was, nor whether or not he had lost it, and gained another domicile, nor of what particular state, if any, he was a citizen. On what ground can it be denied that all valid laws of the United States, constitutionally enacted by Congress for the government of the territory, rightfully extended over an officer of the United States and his servant who went into the territory to remain there for an indefinite length of time, to take part in its civil or military affairs? They were not foreigners, coming from abroad. Dr. Emerson was a citizen of the country which had exclusive jurisdiction over the territory, and not only a citizen, but he went there in a public capacity, in the service of the same sovereignty which made the laws, whatever those laws might be, whether of the kind denominated personal statutes, or not, so far as they were intended by the legislative will, constitutionally expressed, to operate on him and his servant, and on the relations between them. They had the rightful operation, and no other state or country can refuse to allow that those laws might rightfully operate on the plaintiff and his servant, because such a refusal would be a denial that the United States could, by laws constitutionally enacted, govern their own servants, residing on their own territory, over which the United States had the exclusive control, and in respect to which they are an independent sovereign power. Whether the laws now in question were constitutionally enacted, I repeat once more, is a separate question. But, assuming that they were, and that they operated directly on the status of the plaintiff, I considered that no other state or country could question the rightful power of the United States so to legislate, or, consistently with the settled rules of international law, could refuse to recognize the effects 60 U.S. 393, 599 of such legislation upon the status of their officers and servants, as valid everywhere. This alone would, in my apprehension, be sufficient to decide this question. But there are other facts stated on the record which should not be passed over. It is agreed that, in the year 1836, the plaintiff, while residing in the territory, was married, with the consent of Dr. Emerson, to Harriet, named in the declaration as his wife, and that Eliza and Lizzie were the children of that marriage, the first named having been born on the Mississippi River, north of the line of Missouri, and the other having been born after their return to Missouri. And the inquiry is, whether, after the marriage of the plaintiff in the territory, with the consent of Dr. Emerson, any other state or country can, consistently with the settled rules of international law, refuse to recognize and treat him as a free man, when suing for the liberty of himself, his wife, and the children of the marriage. It is in reference to his status, as viewed in other states and countries, that the contract of marriage and the birth of children becomes strictly material. At the same time, it is proper to observe that the female to whom he was married having been taken to the same military post of Fort Snelling as a slave, and Dr. Emerson claiming also to be her master at the time of her marriage, her status, and that of the children of the marriage, are also affected by the same considerations. If the laws of Congress governing the territory of Wisconsin were constitutional and valid laws, there can be no doubt these parties were capable of contracting the lawful marriage, attended with all the usual civil rights and obligations of that condition. In that territory they were absolutely free persons, having full capacity to enter into the civil contract of marriage. It is a principle of international law, settled beyond controversy in England and America, that the marriage, valid by the law of the place where it was contracted, and not in fraud of the law of any other place, is valid everywhere, and that no technical domicile at the place of the contract is necessary to make it so. See Bishop on March and Divided, 125129, where the cases are collected. If, in Missouri, the plaintiff were held to be a slave, the validity and operation of his contract of marriage must be denied. He can have no legal rights, of course, not those of a husband and father. And the same is true of his wife and children. The denial of his rights is the denial of theirs, so that, though lawfully married in the territory, when they came out of it, into the state of Missouri, they were no longer 60 U.S. 393, 600 husband and wife, and a child of that lawful marriage, though born under the same dominion where its parents contracted the lawful marriage, is not the fruit of that marriage, nor the child of its father, but subject to the maxim, partus sequitur ventrem. It must be borne in mind that in this case there is no ground for the inquiry, whether it be the will of the state of Missouri not to recognize the validity of the marriage of a fugitive slave, who escapes into a state or country where slavery is not allowed, and there contracts the marriage, or the validity of such a marriage, where the master, being a citizen of the state of Missouri, voluntarily goes with his slave, in itinerant, into a state or country which does not permit slavery to exist, and the slave there contracts marriage without the consent of his master, for in this case, it is agreed, Dr. Emerson did consent, and no further question can arise concerning his rights, so far as their assertion is inconsistent with the validity of the marriage. Nor do I know of any ground for the assertion that this marriage was in fraud of any law of Missouri. It has been held by this court, that a bequest of property by a master to his slave, by necessary implication entitles the slave to his freedom, because, only as a freeman could he take and hold the bequest. Legrand v. Darnall, 2 Pet. R. 664. It has also been held, that when the master goes with his slave to reside for an indefinite period in a state where slavery is not tolerated, this operates as an act of manumission, because it is sufficiently expressive of the consent of the master that the slave should be freed. To Marshall's Ken. R. 470, 14 Martins Lewis. R. 401. What, then, shall we say of the consent of the master, that the slave may contract a lawful marriage, attended with all the civil rights and duties which belong to that relation, that he may enter into a relation which none but a free man can assume, a relation which involves not only the rights and duties of the slave, but those of the other party to the contract, and their descendants to the remotest generation. In my judgment, there can be no more effectual abandonment of the legal rights of the master over his slave, than by the consent of the master that the slave should enter into a contract of marriage, in a free state, attended by all the civil rights and obligations which belong to that condition. And any claim by Dr. Emerson, or any one claiming under him, the effect of which is to deny the validity of this marriage, and the lawful paternity of the children born from it, wherever asserted, is, in my judgment, a claim inconsistent with good faith and sound reason, as well as with the rules of international law. And I go further, in my opinion, the law of the state 60 U.S. 393, 601 of Missouri, which should thus annul the marriage, lawfully contracted by these parties while resident in Wisconsin, not in fraud of any law of Missouri, or of any right of Dr. Emerson, who consented thereto, would be a law impairing the obligation of a contract, and within the prohibition of the Constitution of the United States. See 4 Wheat, 629, 695, 696. To avoid misapprehension on this important and difficult subject, I will state, distinctly, the conclusions at which I have arrived. They are, first, the rules of international law respecting the emancipation of slaves, by the rightful operation of the laws of another state or country upon the status of the slave, while resident in such foreign state or country, are part of the common law of Missouri, and have not been abrogated by any statute law of that state. Second, the laws of the United States, constitutionally enacted, which operated directly on and changed the status of a slave coming into the territory of Wisconsin with his master, who went thither to reside for an indefinite length of time, in the performance of his duty as an officer of the United States, had a rightful operation on the status of the slave, and it is in conformity with the rules of international law that this change of status should be recognized everywhere. Third, the laws of the United States, in operation in the territory of Wisconsin at the time of the plaintiff's residence there, did act directly on the status of the plaintiff, and changed his status to that of a free man. Fourth, the plaintiff and his wife were capable of contracting, and, with the consent of Dr. Emerson, did contract a marriage in that territory, valid under its laws, and the validity of this marriage cannot be questioned in Missouri, save by showing that it was in fraud of the laws of that state, or of some right derived from them, which cannot be shown in this case, because the master consented to it. Fifth, that the consent of the master that his slave, residing in a country which does not tolerate slavery, may enter into a lawful contract of marriage, attended with the civil rights and duties which being to that condition, is an effectual act of emancipation. And the law does not enable Dr. Emerson, or any one claiming under him, to assert a title to the married persons as slaves, and thus destroy the obligation of the contract of marriage, and bastardize their issue, and reduce them to slavery. But it is insisted that the Supreme Court of Missouri has settled this case by its decision in Scott v. Emerson, 15 Missouri Reports, 576, and that this decision is in conformity 60 U.S. 393, 602 with the weight of authority elsewhere, and with sound principles. If the Supreme Court of Missouri had placed its decision on the ground that it appeared Dr. Emerson never became domiciled in the territory, and so its laws could not rightfully operate on him and his slave, and the facts that he went there to reside indefinitely, as an officer of the United States, and that the plaintiff was lawfully married there, with Dr. Emerson's consent, were let out of view, the decision would find support in other cases, and I might not be prepared to deny its correctness. But the decision is not rested on this ground. The domicile of Dr. Emerson in that territory is not questioned in that decision, and it is placed on a broad denial of the operation, in Missouri, of the law of any foreign state or country upon the status of a slave, going with his master from Missouri into such foreign state or country, even though they went thither to become, and actually became, permanent inhabitants of such foreign state or country. The laws were acted directly on the status of the slave, and changed his status to that of a freeman. To the correctness of such a decision I cannot assent. In my judgment, The opinion of the majority of the court in that case is in conflict with its previous decisions, with a great weight of judicial authority in other slave-holding states, and with fundamental principles of private international law. Mr. Chief Justice Gamble, in his dissenting opinion in that case, said, "I regard the question as conclusively settled by repeated adjudications of this court, and if I doubted or denied the propriety of those decisions, I would not feel myself any more at liberty to overturn them than I would any other series of decisions by which the law upon any other question had been settled. There is with me nothing in the law of slavery which distinguishes it from the law on any other subject, or allows any more accommodation to the temporary excitement which have gathered around it. But in the midst of all such excitement, it is proper that the judicial mind, calm and self-balanced, should adhere to principles established when there was no feeling to disturb the view of the legal questions upon which the rights of parties depend. In this state, it has been recognized from the beginning of the government as a correct position in law, that the master who takes his slave to reside in a state or territory where slavery is prohibited, thereby emancipates his slave." Winnethi Whitesides, 1 MO, 473, Lagrange v. Shodo, 2 MO, 20, Millie v. Smith, IB, 36, Ralph v. Duncan, 3 MO, 194, Julia v. McKinney, IB, 270, Knapp v. Ruddle, IB, 400, Rachel v. Walker, 4 MO, 350, Wilson v. Melvin, 592, 60 U.S. 393, 603. Chief Justice Gamble has also examined the decisions of the courts of other states in which slavery is established, and finds them in accordance with these preceding decisions of the Supreme Court of Missouri to which he refers. It would be a useless parade of learning for me to go over the ground which he is so fully and ably occupied. But it is further insisted we are bound to follow this decision. I do not think so. In this case, it is to be determined what laws of the United States were in operation in the territory of Wisconsin, and what was their effect on the status of the plaintiff. Could the plaintiff contract a lawful marriage there? Does any law of the state of Missouri impair the obligation of that contract of marriage, destroy his rights as a husband, bastardize the issue of the marriage, and reduce them to a state of slavery? These questions, which arise exclusively under the Constitution and laws of the United States, this court, under the Constitution and laws of the United States, has the rightful authority finally to decide. And if we look beyond these questions, we come to the consideration whether the rules of international law, which are part of the laws of Missouri until displaced by some statute not alleged to exist, do or do not require the status of the plaintiff, as fixed by the laws of the territory of Wisconsin, to be recognized in Missouri. Upon such a question, not depending on any statute or local usage, but on principles of universal jurisprudence, this court has repeatedly asserted it could not hold itself bound by the decisions of state courts, however great respect might be felt for their learning, ability, and impartiality. See Swift v. Tyson, 16 Peters R. 1, Carpenter v. The Providence Inns Company, IB, 495, Foxcroft v. Mallet, 4 Howe, 353, Rowden v. Ruddles, 5 Howe, 134. Some reliance has been placed on the fact that the decision in the Supreme Court of Missouri was between these parties, and the suit there was abandoned to obtain another trial in the courts of the United States. In Homer v. Brown, 16 Howe, 354, this court made a decision upon the construction of a devise of lands, in direct opposition to the unanimous opinion of the Supreme Court of Massachusetts, between the same parties, respecting the same subject matter, the claimant having become non-suit in the state court, in order to bring his action in the Circuit Court of the United States. I did not sit in that case, having been of counsel for one of the parties while at the bar, but, on examining the report of the argument of the counsel for the plaintiff in error, I find they made the point that this court ought to give effect to the construction put upon the will by the state 60 U.S. 393, 604 court, to the end that rights respecting lands may be governed by one law, and that the law of the place where the lands are situated, that they referred to the state decision of the case, reported in 3 Cushing, 390, and too many decisions of this court. But this court does not seem to have considered the point of sufficient importance to notice it in their opinions. In Miller v. Austin, 13 Howe, 218, an action was brought by the endorsee of a written promise The question was, whether it was negotiable under a statute of Ohio. The Supreme Court of that state having decided it was not negotiable, the plaintiff became non-suit, and brought his action in the Circuit Court of the United States. The decision of the Supreme Court of the state, reported in 4 D.S. L.J. 527, was relied on. This court unanimously held the paper to be negotiable. When the decisions of the highest court of a state are directly in conflict with each other, it has been repeatedly held, here, that the last decision is not necessarily to be taken as the rule. State Bank v. New, 16 Hout, 369, Pease v. Peck, 18 Hout, 599. To these considerations I desire to add, that it was not made known to the Supreme Court of Missouri, so far as appears, that the plaintiff was married in Wisconsin with the consent of Dr. Emerson, and it is not made known to us that Dr. Emerson was a citizen of Missouri, a fact to which that court seemed to have attached much importance. Sitting here to administer the law between these parties, I do not feel at liberty to surrender my own convictions of what the law requires, to the authority of the decision in 15 Missouri reports. I have thus far assumed, merely for the purpose of the argument, that the laws of the United States, respecting slavery in this territory, were constitutionally enacted by Congress. It remains to inquire whether they are constitutional and binding laws. In the argument of this part of the case at bar, it was justly considered by all the counsel to be necessary to ascertain the source of the power of Congress over the territory belonging to the United States. Until this is ascertained, it is not possible to determine the extent of that power. On the one side, it was maintained that the Constitution contains no express grant of power to organize and govern what is now known to the laws of the United States as a territory, that whatever power of this kind exists, is derived by implication from the capacity of the United States to hold and acquire territory out of the limits of any state, and the necessity for its having some government. 60 U.S. 393, 605. On the other side, it was insisted that the Constitution has not failed to make an express provision for this end, and that it is found in the third section of the fourth article of the Constitution. To determine which of these is the correct view, it is needful to advert to some facts respecting this subject, which existed when the Constitution was framed and adopted. It will be found that these facts not only shed much light on the question, whether the framers of the Constitution omitted to make a provision concerning the power of Congress to organize and govern territories, but they will also aid in the construction of any provision which may have been made respecting this subject. Under the Confederation, the unsettled territory within the limits of the United States had been a subject of deep interest. Some of the states insisted that these lands were within their chartered boundaries, and that they had succeeded to the title of the Crown to the soil. On the other hand, it was argued that the vacant lands had been acquired by the United States, by the war carried on by them under a common government and for the common interest. This dispute was further complicated by unsettled questions of boundary among several states. It not only delayed the accession of Maryland to the Confederation, but at one time seriously threatened its existence. 5 Sure. Of Cong. 208, 442. Under the pressure of these circumstances, Congress earnestly recommended to the several states a cession of their claims and rights to the United States. 5 Sure. Of Cong. 442. And before the Constitution was framed, it had been begun. That by New York had been made on the 1st day of March, 1781, that of Virginia on the 1st day of March, 1784, that of Massachusetts on the 19th day of April, 1785, that of Connecticut on the 14th day of September, 1786, that of South Carolina on the 8th day of August, 1787, while the convention for framing the Constitution was in session. It is very material to observe, in this connection, that each of these accedes, in terms, to the United States, as well the jurisdiction as the soil. It is also equally important to know that, when the Constitution was framed and adopted, this plan of vesting in the United States, for the common good, the great tracts of ungranted lands claimed by the several states, in which so deep an interest was felt, was yet incomplete. It remained for North Carolina and Georgia to cede their extensive and valuable claims. These were made by North Carolina on the 25th day of February, 1790, and by Georgia on the 24th day of April, 60 U.S. 393, 606 1802. The terms of these last-mentioned cessions will hereafter be noticed in another connection, but I observe here that each of them distinctly shows, upon its face, that they were not only an execution of the general plan proposed by the Congress of the Confederation, but of a formed purpose of each of these states, existing when the assent of their respective people was given to the Constitution of the United States. It appears, then, that when the Federal Constitution was framed, and presented to the people of the several states for their consideration, the unsettled territory was viewed as justly applicable to the common benefit, so far as it then had or might attain thereafter a pecuniary value, and so far as it might become the seat of new states, to be admitted into the Union upon an equal footing with the original states, and also that the relations of the United States to that unsettled territory were of different kinds. The titles of the states of New York, Virginia, Massachusetts, Connecticut, and South Carolina, as well of soil as of jurisdiction, had been transferred to the United States. North Carolina and Georgia had not actually made transfers, but a confident expectation, founded on their appreciation of the justice of the general claim, and fully justified by the results, was entertained, that these cessions would be made. The Ordinance of 1787 had made provision for the temporary government of so much of the territory actually ceded as lay northwest of the river Ohio. But it must have been apparent, both to the framers of the Constitution and the people of the several states who were to act upon it, that the government thus provided for could not continue, unless the Constitution should confer on the United States the necessary powers to continue it. That temporary government, under the ordinance, was to consist of certain officers, to be appointed by and responsible to the Congress of the Confederation. Their powers had been conferred and defined by the ordinance. So far as it provided for the temporary government of the territory, it was an ordinary act of legislation, deriving its force from the legislative power of Congress, and depending for its vitality upon the continuance of that legislative power. But the officers to be appointed for the Northwestern Territory, after the adoption of the Constitution, must necessarily be officers of the United States, and not of the Congress of the Confederation, appointed and commissioned by the President, and exercising powers derived from the United States under the Constitution. Such was the relation between the United States and the Northwestern Territory, which all reflecting men must have foreseen would exist, when the government created by the 60 U.S. 393, 607 Constitution should supersede that of the Confederation. That if the new government should be without power to govern this territory, it could not appoint and commission officers, and send them into the territory, to exercise their legislative, judicial, and executive power, and that this territory, which was even then foreseen to be so important, both politically and financially, to all the existing states, must be left not only without the control of the general government, in respect to its future political relations to the rest of the states, but absolutely without any government, save what its inhabitants, acting in their primary capacity, might from time to time create for themselves. But this Northwestern Territory was not the only territory. The soil and jurisdiction were then understood to have been ceded to the United States. The cession by South Carolina, made in August 1787, was of all the territory included within the river Mississippi, and the line beginning at that part of the said river which is intercepted by the southern boundary of North Carolina, and continuing along the said boundary line until it intersects the ridge or chain of mountains which divides the eastern from the western waters, then to be continued along the top of the said ridge of mountains, until it intersects the line to be drawn due west from the head of the southern branch of the Tougaloo River, to the said mountains, and thence to run a due west course to the river Mississippi. It is true that by subsequent explorations it was ascertained that the source of the Tougaloo River, upon which the title of South Carolina depended, was so far to the northward, that the transfer conveyed only a narrow slip of land, about 12 miles wide, lying on the top of the ridge of mountains, and extending from the northern boundary of Georgia to the southern boundary of North Carolina. But this was a discovery made long after the cession, and there can be no doubt that the state of South Carolina, in making the cession, and the Congress in accepting it, viewed it as a transfer to the United States of the soil and jurisdiction of an extensive and important part of the unsettled territory ceded by the Crown of Great Britain by the Treaty of Peace, though its quantity or extent then remained to be ascertained. 5. It must be remembered also, as has been already stated, that not only was there the confident expectation entertained by the 60 U.S. 393, 608 other states, that North Carolina and Georgia would complete the plan already so far executed by New York, Virginia, Massachusetts, Connecticut, and South Carolina, but that the opinion was in no small degree prevalent that the just title to this back country, as it was termed, had vested in the United States by the Treaty of Peace, and could not rightfully be claimed by any individual state. There is another consideration applicable to this part of the subject, and entitled, in my judgment, too great weight. The Congress of the Confederation had assumed the power not only to dispose of the lands ceded, but to institute governments and make laws for their inhabitants. In other words, they had proceeded to act under the cession, which, as we have seen, was as well of the jurisdiction as of the soil. This ordinance was passed on the 13th of July, 1787. The convention for framing the Constitution was then in session at Philadelphia. The proof is direct and decisive that it was known to the convention. 6. It is equally clear that it was admitted and understood not to be within the legitimate powers of the Confederation to pass this ordinance. Jefferson's Works, Volume 9, pages 251, 276, Federalist, N.O.S. 38, 43. The importance of conferring on the new government regular powers commensurate with the objects to be attained, and thus avoiding the alternative of a failure to execute the trust assumed by the acceptance of the cessions made and expected, or its execution by usurpation, could scarcely fail to be perceived. That it was in fact perceived, is clearly shown by the Federalist, number 38, where this very argument is made use of in commendation of the Constitution. Keeping these facts in view, it may confidently be asserted that there is very strong reason to believe, before we examine the Constitution itself, that the necessity for a competent grant of power to hold, dispose of, and govern territory, ceded and expected to be ceded, could not have escaped the attention of those who framed or adopted the Constitution, and that if it did not escape their attention, it could not fail to be adequately provided for. Any other conclusion would involve the assumption that a subject of the greatest national concern, respecting which the small states felt so much jealousy that it had been almost an insurmountable obstacle to the formation of the Confederation, and as to which all the states had deep pecuniary and political interests, and which had been so recently and constantly agitated. 60 U.S. 393, 609 was nevertheless overlooked, or that such a subject was not overlooked, but designedly left unprovided for, though it was manifestly a subject of common concern, which belonged to the care of the general government, and adequate provision for which could not fail to be deemed necessary and proper. The admission of new states, to be framed out of the ceded territory, early attracted the attention of the convention. Among the resolutions introduced by Mr. Randolph, on the 29th of May, was one on this subject, Res. Number 10, 5 Elliott, 128, which, having been affirmed in Committee of the Whole, on the 5th of June, 5 Elliott, 156, and reported to the convention on the 13th of June, 5 Elliott, 190, was referred to the Committee of Detail, to prepare the Constitution, on the 26th of July, 5 Elliott, 376. This committee reported an article for the admission of new states lawfully constituted or established. Nothing was said concerning the power of Congress to prepare or form such states. This omission struck Mr. Madison, who, on the 18th of August, 5 Elliott, 439, moved for the insertion of power to dispose of the unappropriated lands of the United States, and to institute temporary governments or new states arising therein. On the 29th of August, 5 Elliott, 492, the report of the committee was taken up, and after debate, which exhibited great diversity of views concerning the proper mode of providing for the subject, arising out of the supposed diversity of interests of the large and small states, and between those which had and those which had not unsettled territory, but no difference of opinion respecting the propriety and necessity of some adequate provision for the subject, Gouverneur Morris moved the clause as it stands in the Constitution. This met with general approbation, and was at once adopted. The whole section is as follows: New states may be admitted by the Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states, or parts of states, without the consent of the legislatures of the states concerned, as well as of Congress. that Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. That Congress has some power to institute temporary governments over the territory, I believe all agree, and, if it be admitted that the necessity of some power to govern the territory 60 U.S. 393, 610 of the United States could not and did not escape the attention of the Convention and the people, and that the necessity is so great, that, in the absence of any express grant, it is strong enough to raise an implication of the existence of that power, it would seem to follow that it is also strong enough to afford material aid in construing an express grant of power respecting that territory, and that they who maintain the existence of the power, without finding any words at all in which it is conveyed, should be willing to receive a reasonable interpretation of language of the Constitution, manifestly intended to relate to the territory, and to convey to Congress some authority concerning it. It would seem, also, that when we find the subject matter of the growth and formation and admission of new states, and the disposal of the territory for these ends, were under consideration, and that some provision therefore was expressly made, it is improbable that it would be, in its terms, the grossly inadequate provision, and that an indispensably necessary power to institute temporary governments, and to legislate for the inhabitants of the territory, was passed silently by, and left to be deduced from the necessity of the case. In the argument at the bar, great attention has been paid to the meaning of the word territory. Ordinarily, when the territory of a sovereign power is spoken of, it refers to that tract of country which is under the political jurisdiction of that sovereign power. Thus Chief Justice Marshall in United States v. Bevins, 3 Wheat, 386 says, "What, then, is the extent of jurisdiction which a state possesses?" We answer, without hesitation, the jurisdiction of a state is coextensive with its territory. Examples might easily be multiplied of this use of the word, but they are unnecessary, because it is familiar. But the word territory is not used in this broad and general sense in this clause of the Constitution. At the time of the adoption of the Constitution, the United States held a great tract of country northwest of the Ohio, another tract, then of unknown extent, ceded by South Carolina, and a confident expectation was then entertained, and afterwards realized, that they then were or would become the owners of other great tracts, claimed by North Carolina and Georgia. These ceded tracts lay within the limits of the United States, and out of the limits of any particular state, and the cessions embraced the civil and political jurisdiction, and so much of the soil as had not previously been granted to individuals. These words, territory belonging to the United States, 60 U.S. 393, 611 were not used in the Constitution to describe an abstraction, but to identify and apply to these actual subjects matter then existing and belonging to the United States, and other similar subjects which might afterwards be acquired, and, this being so, all the essential qualities and incidents attending such actual subjects are embraced within the words territory belonging to the United States, as fully as if each of those essential qualities and incidents had been specifically described. I say, the essential qualities and incidents. But in determining what were the essential qualities and incidents of the subject with which they were dealing, we must take into consideration not only all the particular facts which were immediately before them, but the great consideration, ever present to the minds of those who framed and adopted the Constitution, that they were making a frame of government for the people of the United States and their posterity, under which they hoped the United States might be, what they have now become, a great and powerful nation, possessing the power to make war and to conclude treaties, and thus to acquire territory. See Fair v. Tito, 6 Cr. 336, M. Hins. Company v. Cantor, 1 Pet. 542. With these in view, I turn to examine the clause of the article now in question. It is said this provision has no application to any territory save that then belonging to the United States. I have already shown that, when the Constitution was framed, a confident expectation was entertained, which was speedily realized, that North Carolina and Georgia would cede their claims to that great territory which lay west of those states. No doubt has been suggested that the first clause of this same article, which enabled Congress to admit new states, refers to and includes new states to be formed out of this territory, expected to be thereafter ceded by North Carolina and Georgia, as well as new states to be formed out of territory northwest of the Ohio, which then had been ceded by Virginia. It must have been seen, therefore, that the same necessity would exist for an authority to dispose of and make all needful regulations respecting this territory, when ceded, as existed for a like authority respecting territory which had been ceded. No reason has been suggested why any reluctance should have been felt by the framers of the Constitution to apply this provision to all the territory which might belong to the United States, or why any distinction should have been made, founded on the accidental circumstance of the dates of the sessions, the circumstance in no way material as respects the necessity for rules and regulations, or the propriety of conferring 60 U.S. 393, 612 on the Congress power to make them. And if we look at the course of the debates in the Convention on this article, we shall find that the then UNC lands, so far from having been left out of view in adopting this article, constituted, in the minds of members, the subject of even paramount importance. Again, in what an extraordinary position would the limitation of this clause to territory then belonging to the United States place the territory which lay within the chartered limits of North Carolina and Georgia? The title to that territory was then claimed by those states, and by the United States. Their respective claims are purposely left unsettled by the express words of this clause, and when cessions were made by those states, they were merely of their claims to this territory, the United States, neither admitting nor denying the validity of those claims, so that it was impossible then, and has ever since remained impossible, to know whether this territory did or did not then belong to the United States, and, consequently, to know whether it was within or without the authority conferred by this clause to dispose of and make rules and regulations respecting the territory of the United States. This attributes to the eminent men who acted on this subject a want of ability and forecast, or a want of attention to the known facts upon which they were acting, in which I cannot concur. There is not, in my judgment, anything in the language, the history, or the subject matter of this article, which restricts its operation to territory owned by the United States when the Constitution was adopted. But it is also insisted that provisions of the Constitution respecting territory belonging to the United States do not apply to territory acquired by treaty from a foreign nation. This objection must rest upon the position that the Constitution did not authorize the federal government to acquire foreign territory, and consequently has made no provision for its government when acquired, or that though the acquisition of foreign territory was contemplated by the Constitution, its provisions concerning the admission of new states, and the making of all needful rules and regulations respecting territory belonging to the United States, were not designed to be applicable to territory acquired from foreign nations. It is undoubtedly true that at the date of the Treaty of 1803, between the United States and France, for the cession of Louisiana, it was made a question whether the Constitution had conferred on the executive department of the government of the United States power to acquire foreign territory. By the treaty, 60 U.S. 393, 613, there is evidence that very grave doubts were then entertained concerning the existence of this power, but that there was then a settled opinion in the executive and legislative branches of the government that this power did not exist, cannot be admitted, without at the same time imputing to those who negotiated and ratified the treaty, and passed the laws necessary to carry it into execution, a deliberate and known violation of their oaths to support the Constitution, and whatever doubts may them have existed, the question must now be taken to have been settled. For distinct acquisitions of foreign territory have been made by as many different treaties, under as many different administrations. 6 states, formed on such territory, are now in the Union. Every branch of this government, during a period of more than 50 years, has participated in these transactions. To question their validity now is vain. As was said by Mr. Chief Justice Marshall, in the American Insurance Company v. Cantor, 1 Peters, 542, the Constitution confers absolutely on the government of the Union the powers of making war and of making treaties. Consequently, that government possesses the power of acquiring territory, either by conquest or war treaty. See Fair v. Tito, 6 Cr. 336. And I add, it also possesses the power of governing it, when acquired, not by resorting to supposititious powers, nowhere found described in the Constitution, but expressly granted it the authority to make all needful rules and regulations respecting the territory of the United States. There was to be established by the Constitution a frame of government, under which the people of the United States and their posterity were to continue indefinitely. To take one of its provisions, the language of which is broad enough to extend throughout the existence of the government, and embrace all territory belonging to the United States throughout all time, and the purposes and objects of which apply to all territory of the United States, and narrow it down to territory belonging to the United States when the Constitution was framed, while at the same time it is admitted that the Constitution contemplated and authorized the acquisition, from time to time, of other and foreign territory, seems to me to be an interpretation as inconsistent with the nature and purposes of the instrument, as it is with its language, and I can have no hesitation in rejecting it. I construe this clause, therefore, as if it had read, Congress shall have power to make all needful rules and regulations respecting those tracts of country, out of the limits of the several states, which the United States have acquired, or may hereafter acquire, by cessions, as well of the jurisdiction as of the 60 U.S. 393, 614 soil, so far as the soil may be the property of the party making the cession, at the time of making it. It has been urged that the words rules and regulations are not appropriate terms in which to convey authority to make laws for the government of the territory. But it must be remembered that this is a grant of power to the Congress, that it is therefore necessarily a grant of power to legislate, and, certainly, rules and regulations respecting a particular subject, made by the legislative power of a country, can be nothing but laws. Nor do the particular terms employed, in my judgment, tend in any degree to restrict this legislative power. Power granted to a legislature to make all needful rules and regulations respecting the territory, is a power to pass all needful laws respecting it. The word regulate, or regulation, is several times used in the Constitution. It is used in the fourth section of the first article to describe those laws of the states which prescribe the times, places, and manner of choosing senators and representatives, in the second section of the fourth article, to designate the legislative action of a state on the subject of fugitives from service, having a very close relation to the matter of our present inquiry, in the second section of the third article, to empower Congress to fix the extent of the appellate jurisdiction of this court, and, finally, in the eighth section of the first article are the words, Congress shall have power to regulate commerce. It is unnecessary to describe the body of legislation which has been enacted under this grant of power. Its variety and extent are well known. But it may be mentioned, in passing, that under this power to regulate commerce, Congress has enacted a great system of municipal laws, and extended it over the vessels and crews of the United States on the high seas and in foreign ports, and even over citizens of the United States resident in China, and has established judicatures, with power to inflict even capital punishment within that country. If, then, this clause does contain the power to legislate respecting the territory, what are the limits of that power? To this I answer, that, in common with all the other legislative powers of Congress, it finds limits in the express prohibitions on Congress not to do certain things, that, in the exercise of the legislative power, Congress cannot pass an ex post facto law or bill of attainder, and so in respect to each of the other prohibitions contained in the Constitution. Besides this, the rules and regulations must be needful. But undoubtedly the question whether a particular rule or regulation be needful, must be finally determined by Congress itself. Whether a law be needful, is a legislative or political, 60 U.S. 393, 615 not a judicial, question. Whatever Congress deems needful is so, under the grant of power. Nor am I aware that it has ever been questioned that laws providing for the temporary government of the settlers on the public lands are needful, not only to prepare them for admission to the Union as states, but even to enable the United States to dispose of the lands. Without government and social order, there can be no property, for without law, its ownership, its use, and the power of disposing of it, cease to exist, in the sense in which those words are used and understood in all civilized states. Since, then, this power was manifestly conferred to enable the United States to dispose of its public lands to settlers, and to admit them into the Union as states, when in the judgment of Congress they should be fitted therefore, since these were the needs provided for, since it is confessed that government is indispensable to provide for those needs, and the power is to make all needful rules and regulations respecting the territory. I cannot doubt that this is a power to govern the inhabitants of the territory, by such laws as Congress deems needful, until they obtain admission as states. Whether they should be thus governed solely by laws enacted by Congress, or partly by laws enacted by legislative power conferred by Congress, is one of those questions which depends on the judgment of Congress, a question which of these is needful. But it is insisted that whatever other powers Congress may have respecting the territory of the United States, the subject of Negro slavery forms an exception. The Constitution declares that Congress shall have power to make all needful rules and regulations respecting the territory belonging to the United States. The assertion is, though the Constitution says all, it does not mean although it says all, without qualification. It means all except such as allow or prohibit slavery. It cannot be doubted that it is incumbent on those who would thus introduce an exception not found in the language of the instrument, to exhibit some solid and satisfactory reason, drawn from the subject matter or the purposes and objects of the clause, the context, or from other provisions of the Constitution, showing that the words employed in this clause are not to be understood according to their clear, plain, and natural signification. The subject matter is the territory of the United States out of the limits of every state, and consequently under the exclusive power of the people of the United States. There 60 U.S. 393, 616 will respecting it, manifested in the Constitution, can be subject to no restriction. The purposes and objects of the clause were the enactment of laws concerning the disposal of the public lands, and the temporary government of the settlers thereon until new states should be formed. It will not be questioned that, when the Constitution of the United States was framed and adopted, the allowance and the prohibition of Negro slavery were recognized subjects of municipal legislation. Every state had in some measure acted thereon, and the only legislative fact concerning the territory, the Ordinance of 1787, which had then so recently been passed, contained a prohibition of slavery. The purpose and object of the clause being to enable Congress to provide a body of municipal law for the government of the settlers. The allowance for the prohibition of slavery comes within the known and recognized scope of that purpose and object. There is nothing in the context which qualifies the grant of power. The regulations must be respecting the territory. An enactment that slavery may or may not exist there is a regulation respecting the territory. Regulations must be needful, but it is necessarily left to the legislative discretion to determine whether a law be needful. No other clause of the Constitution has been referred to at the bar, or has been seen by me, which imposes any restriction or makes any exception concerning the power of Congress to allow or prohibit slavery in the territory belonging to the United States. A practical construction, nearly contemporaneous with the adoption of the Constitution, and continued by repeated instances through a long series of years, may always influence, and in doubtful cases should determine, the judicial mind, on a question of the interpretation of the Constitution. Stewart v. Laird, 1 Grant, 269, Martin v. Hunter, 1 Wheat, 304, Coutens v. Virginia, 6 Wheat, 264, Pritt v. Pennsylvania, 16 Pet, 621, Cooley v. Port Wardens, 12 Howe, 315. In this view, I proceed briefly to examine the practical construction placed on the clause now in question, so far as it respects the inclusion therein of power to permit or prohibit slavery in the territories. It has already been stated that after the government of the United States was organized under the Constitution, the temporary government of the territory northwest of the River Ohio could no longer exist, save under the powers conferred on Congress by the Constitution. Whatever legislative, judicial, or executive authority should be exercised therein could be derived only from the people of the United States under the Constitution. And, accordingly, an act was passed on the 60 U.S. 393, 617 7th day of August, 1789, one stat at large, 50, which recites, whereas, in order that the ordinance of the United States in Congress assembled, for the government of the territory northwest of the River Ohio, may continue to have full effect, it is required that certain provisions should be made, so as to adapt the same to the present Constitution of the United States. It then provides for the appointment by the President of all officers, who, by force of the ordinance, were to have been appointed by the Congress of the Confederation, and their commission in the manner required by the Constitution, and empowers the Secretary of the Territory to exercise the powers of the Governor in case of the death or necessary absence of the latter. Here is an explicit declaration of the will of the First Congress, of which 14 members, including Mr. Madison, had been members of the convention which framed the Constitution, that the ordinance, one article of which prohibited slavery, should continue to have full effect. General Washington, who signed this bill, as President, was the President of that convention. It does not appear to me to be important, in this connection, that clause in the ordinance which prohibited slavery was one of a series of articles of what is therein termed a compact. The Congress of the Confederation had no power to make such a compact, nor to act at all on the subject, and after what had been so recently said by Mr. Madison on this subject, in the 38th number of the Federalist, I cannot suppose that he, or any others, who voted for this bill, attributed any intrinsic effect to what was denominated in the ordinance a compact between the original states and the people and states in the new territory, there being no new states then in existence in the territory, with whom a compact could be made, and the few scattered inhabitants, unorganized into a political body, not being capable of becoming a party to a treaty, even if the Congress of the Confederation had had power to make one touching the government of that territory. I consider the passage of this law to have been an assertion by the First Congress of the power of the United States to prohibit slavery within this part of the territory of the United States, for it clearly shows that slavery was thereafter to be prohibited there, and it could be prohibited only by an exertion of the power of the United States, under the Constitution, no other power being capable of operating within that territory after the Constitution took effect. On the 2nd of April, 1790, one Stat. At large, 106, the First Congress passed an act accepting a deed of cession by North 60 U.S. 393, 618 Carolina of that territory afterwards erected into the state of Tennessee. The fourth express condition contained in this deed of cession, after providing that the inhabitants of the territory shall be temporarily governed in the same manner as those beyond the Ohio, is followed by these words, provided, always, that no regulations made or to be made by Congress shall tend to emancipate slaves. This provision shows that it was then understood Congress might make a regulation prohibiting slavery, and that Congress might also allow it to continue to exist in the territory, and accordingly, when, a few days later, Congress passed the Act of May 20, 1790, one Stat. At large, 123, for the government of the territory south of the river Ohio, it provided, and the government of the territory south of the Ohio shall be similar to that now exercised in the territory northwest of the Ohio, except so far as is otherwise provided in the conditions expressed in an act of Congress of the present session, entitled, an act to accept the cession of the claims of the state of North Carolina to a certain district of Western Territory. Under the government thus established, slavery existed until the territory became the state of Tennessee. On the 7th of April, 1798, one Stat. At large, 649, an act was passed to establish a government in the Mississippi Territory in all respects like that exercised in the territory northwest of the Ohio, excepting and excluding the last article of the ordinance made for the government thereof by the late Congress, on the 13th day of July, 1787, when the limits of this territory had been amicably settled with Georgia, and the latter ceded all its claim thereto. It was one stipulation in the compact of cession, that the ordinance of July 13, 1787, shall in all its parts extend to the territory contained in the present act of cession, the article only excepted which forbids slavery. The government of this territory was subsequently established and organized under the Act of May 10, 1800, but so much of the ordinance as prohibited slavery was not put in operation there. Without going minutely into the details of each case, I will now give reference to two classes of acts, in one of which Congress has extended the ordinance of 1787, including the article prohibiting slavery, over different territories, and thus exerted its power to prohibit it. In the other, Congress has erected governments over territories acquired from France and Spain, in which slavery already existed, but refused to apply to them that part of the government under the ordinance which excluded slavery. Of the first class are the Act of May 7, 1800, to state, at 60 U.S. 393, 619 large, 58, for the government of the Indiana Territory, the Act of January 11, 1805, to state, at large, 309, for the government of Michigan Territory, the Act of May 3d, 1809, to state, At large, 514, for the government of the Illinois Territory, the Act of April 20, 1836, 5 Stat. At large, 10, for the government of the Territory of Wisconsin, the Act of June 12, 1838, for the government of the Territory of Iowa, the Act of August 14, 1848, for the government of the Territory of Oregon. To these instances should be added the Act of March 6, 1820, 3 Stat. At large, 548, prohibiting slavery in the territory acquired from France, being northwest of Missouri, and north of 36 degrees 30 minutes north latitude. Of the second class, in which Congress refused to interfere with slavery already existing under the municipal law of France or Spain, and established governments by which slavery was recognized and allowed, are the Act of March 26, 1804, to state. At large, 283, for the government of Louisiana, the Act of March 2, 1805, to state. At large, 322, for the government of the Territory of Orleans, the Act of June 4, 1812, to state. At large, 743, for the government of the Missouri Territory, the Act of March 30, 1822, 3 Stat. At large, 654, for the government of the Territory of Florida. Here are 8 distinct instances, beginning with the first Congress, and coming down to the year 1848, in which Congress has excluded slavery from the territory of the United States, and 6 distinct instances in which Congress organized governments of territories by which slavery was recognized and continued, beginning also with the first Congress, and coming down to the year 1822. These acts were severally signed by 7 presidents of the United States, beginning with General Washington, and coming regularly down as far as Mr. John Quincy Adams, thus including all who were in public life when the Constitution was adopted. If the practical construction of the Constitution contemporaneously with its going into effect, by men intimately acquainted with its history from their personal participation in framing and adopting it, and continued by them through a long series of acts of the greatest importance, be entitled to wait in the judicial mind on a question of construction, it would seem to be difficult to resist the force of the acts above adverted to. It appears, however, from what has taken place at the bar, that notwithstanding the language of the Constitution, and the long line of legislative and executive precedents under it, 3 different and opposite views are taken of the power of Congress respecting slavery in the territories. 60 U.S. 393, 621 is, that though Congress can make a regulation prohibiting slavery in a territory, they cannot make a regulation allowing it. Another is, that it can't neither be established nor prohibited by Congress, but that the people of a territory, when organized by Congress, can establish or prohibit slavery, while the third is, that the Constitution itself secures to every citizen who holds slaves, under the laws of any state, the indefeasible right to carry them into any territory, and there hold them as property. No particular clause of the Constitution has been referred to at the bar in support of either of these views. The first seems to be rested upon general considerations concerning the social and moral evils of slavery, its relations to republican governments, its inconsistency with the Declaration of Independence and with natural right. The second is drawn from consideration equally general, concerning the right of self-government, and the nature of the political institutions which have been established by the people of the United States. While the third is said to rest upon the equal right of all citizens to go with their property upon the public domain, and the inequality of a regulation which would admit the property of some and exclude the property of other citizens, and, inasmuch as slaves are chiefly held by citizens of those particular states where slavery is established, it is insisted that a regulation excluding slavery from a territory operates, practically, to make an unjust discrimination between citizens of different states, in respect to their use and enjoyment of the territory of the United States. With the weight of either of these considerations, when presented to Congress to influence its action, this court has no concern. One or the other may be justly entitled to guide or control the legislative judgment upon what is the needful regulation. The question here is, whether they are sufficient to authorize this court to insert into this clause of the Constitution an exception of the exclusion or allowance of slavery, not found therein, nor in any other part of that instrument. To engraft on any instrument a substantive exception not found in it, must be admitted to be a matter attended with great difficulty, and the difficulty increases with the importance of the instrument, and the magnitude and complexity of the interests involved in its construction. To allow this to be done with the Constitution, upon reasons purely political, renders its judicial interpretation impossible because judicial tribunals, as such, cannot decide upon political considerations. Political reasons have not the requisite certainty to afford rules of juridical 60 U.S. 393, 621 interpretation. They are different in different men. They are different in the same men at different times. And when the strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we have no longer a Constitution. We are under the government of individual men, who for the time being have power to declare what the Constitution is, according to their own views of what it ought to mean. When such a method of interpretation of the Constitution obtains, in place of the Republican government, with limited and defined powers, we have a government which is merely an exponent of the will of Congress, or what, in my opinion, would not be preferable, an exponent of the individual political opinions of the members of this court. If it can be shown, by anything in the Constitution itself, that when it confers on Congress the power to make all needful rules and regulations respecting the territory belonging to the United States, the exclusion or the allowance of slavery was accepted, or if anything in the history of this provision tends to show that such an exception was intended by those who framed and adopted the Constitution to be introduced into it, I hold it to be my duty carefully to consider, and to allow just weight to such considerations in interpreting the positive text of the Constitution. But where the Constitution has said all needful rules and regulations, I must find something more than theoretical reasoning to induce me to say it did not mean all. There have been eminent instances in this court closely analogous to this one, in which such an attempt to introduce an exception, not found in the Constitution itself, has failed of success. By the 8th section of the first article, Congress has the power of exclusive legislation in all cases whatsoever within this district. In the case of Lonsborough v. Blake, 5 Wheat, 324, the question arose, whether Congress has power to impose direct taxes on persons and property in this district. It was insisted that though the grant of power was in its terms broad enough to include direct taxation, it must be limited by the principle that taxation and representation are inseparable. It would not be easy to fix on any political truth, better established or more fully admitted in our country, than that taxation and representation must exist together. We went into the War of the Revolution to assert it, and it is incorporated as fundamental into all American governments. But however true and important 60 U.S. 393, 622 this maxim may be, it is not necessarily of universal application. It was for the people of the United States, who ordained the Constitution, to decide whether it should or should not be permitted to operate within this district. Their decision was embodied in the words of the Constitution, and as that contained no such exception as would permit the maxim to operate in this district, this court, interpreting that language, held that the exception did not exist. Again, the Constitution confers on Congress power to regulate commerce with foreign nations. Under this, Congress passed an act on the 22nd of December, 1807, unlimited in duration, laying an embargo on all ships and vessels in the ports or within the limits and jurisdiction of the United States. No law of the United States ever pressed so severely upon particular states. Though the constitutionality of the law was contested with an earnestness and zeal proportioned to the ruinous effects which were felt from it, and though, as Mr. Chief Justice Marshall has said, 9 Wheat, 192, a want of acuteness in discovering objections to a measure to which they felt the most deep-rooted hostility will not be imputed to those who were arrayed in opposition to this, I am not aware that the fact that it prohibited the use of a particular species of property, belonging almost exclusively to citizens of a few states, and this indefinitely, was ever supposed to show that it was unconstitutional. Something much more stringent, as a ground of legal judgment, was relying on that the power to regulate commerce did not include the power to annihilate commerce. But the decision was, that under the power to regulate commerce, the power of Congress over the subject was restricted only by those exceptions and limitations contained in the Constitution, and as neither the clause in question, which was of general grant of power to regulate commerce, nor any other clause of the Constitution, imposed any restrictions as to the duration of an embargo, an unlimited prohibition of the use of the shipping of the country was within the power of Congress. On this subject, Mr. Justice Daniel, speaking for the court in the case of United States v. Marigold, 9 How. 560, says, Congress are, by the Constitution, vested with the power to regulate commerce with foreign nations, and however, that periods of high excitement, when application of the terms to regulate commerce, such as would embrace absolute prohibition, may have been questioned, yet, since the passage of the embargo and non-intercourse laws, and the repeated judicial sanctions these statutes have received, it can scarcely to this day be open to doubt, that every subject falling legitimately 60 U.S. 393, 623 within the sphere of commercial regulation may be, partially or wholly excluded, when either measure shall be demanded by the safety or the important interests of the entire nation. The power once conceded, it may operate on any and every subject of commerce to which the legislative discretion may apply it. If power to regulate commerce extends to an indefinite prohibition of the use of all vessels belonging to citizens of the several states, and may operate, without exception, upon every subject of commerce to which the legislative discretion may apply it, upon what grounds can I say that power to make all needful rules and regulations respecting the territory of the United States is subject to an exception to the allowance or prohibition of slavery therein? While the regulation is one respecting the territory, while it is, in the judgment of Congress, the needful regulation, and is thus completely within the words of the grant, while no other clause of the Constitution can be shown, which requires the insertion of an exception respecting slavery, and while the practical construction for a period of upwards of 50 years forbids such an exception, it would, in my opinion, violate every sound rule of interpretation to force that exception into the Constitution upon the strength of abstract political reasoning, which we are bound to believe the people of the United States thought insufficient to induce them to limit the power of Congress, because what they have said contains no such limitation. Before I proceed further to notice some other grounds of supposed objection to this power of Congress, I desire to say, that if it were not for my anxiety to insist upon what I deem a correct exposition of the Constitution, if I looked only to the purposes of the argument, the source of the power of Congress asserted in the opinion of the majority of the court would answer those purposes equally well. For they admit that Congress has power to organize and govern the territories until they arrive at a suitable condition for admission to the Union. They admit, also, that the kind of government which shall thus exist should be regulated by the condition and wants of each territory, and that it is necessarily committed to the discretion of Congress to enact such laws for that purpose as that discretion may dictate, and no limit to that discretion has been shown, or even suggested, save those positive prohibitions to legislate, which are found in the Constitution. I confess myself unable to perceive any difference whatever between my own opinion of the general extent of the power of Congress and the opinion of the majority of the court, save 60 U.S. 393, 624 that I consider it derivable from the express language of the Constitution, while they hold it to be silently implied from the power to acquire territory. Looking at the power of Congress over the territories as of the extent just described, what positive prohibition exists in the Constitution, which restrained Congress from enacting a law in 1820 to prohibit slavery north of 36 degrees 30 minutes north latitude? The only one suggested is that clause in the 5th article of the amendments of the Constitution which declares that no person shall be deprived of his life, liberty, or property, without due process of law. I will now proceed to examine the question, whether this clause is entitled to the effect thus attributed to it. It is necessary, first, to have a clear view of the nature and incidence of that particular species of property which is now in question. Slavery, being contrary to natural right, is created only by municipal law. This is not only plain in itself, and agreed by all writers on the subject, but is inferable from the Constitution, and has been explicitly declared by this court. The Constitution refers to slaves as persons held to service in one state, under the laws thereof. Nothing can more clearly describe a status created by municipal law. In Brigg v. Pennsylvania, 10 Pet. 611, this court said, the state of slavery is deemed to be a mere municipal regulation, founded on and limited to the range of territorial laws. In Rankin v. Lydia, 2 March, 12, 470, the Supreme Court of Appeals of Kentucky said, slavery is sanctioned by the laws of this state, and the right to hold them under our municipal regulations is unquestionable. but we view this as a right existing by positive law of a municipal character, without foundation in the law of nature or the unwritten common law. I am not acquainted with any case or writer questioning the correctness of this doctrine. See also 1 Burge, L. and 4 Laws, 738-741, where the authorities are collected. The status of slavery is not necessarily always attended with the same powers on the part of the master. The master is subject to the supreme power of the state, whose will controls his action towards his slave, and this control must be defined and regulated by the municipal law. In one state, as at one period of the Roman law, it may put the life of the slave into the hand of the master. Others, as those of the United States, which tolerate slavery, may treat the slave as a person, when the master takes his life, while in others, the law may recognize the right of the slave to be protected from cruel treatment. In other words, the status of slavery embraces every condition, from that in which the slave is known to the law simply as a 60 U.S. 393, 625 chattel, with no civil rights, to that in which he is recognized as a person for all purposes, save the compulsory power of directing and receiving the fruits of his labor. Which of these conditions shall attend the status of slavery, must depend on the municipal law which creates and upholds it. And not only must the status of slavery be created and measured by municipal law, but the rights, powers, and obligations, which grow out of that status, must be defined, protected, and enforced by such laws. The liability of the master for the torts and crimes of his slave, and of third persons for assaulting or injuring or harboring or kidnapping him, the forms and modes of emancipation and sale, their subjection to the debts of the master, succession by death of the master, suits for freedom, the capacity of the slave to be party to a suit, or to be a witness, with such police regulations as have existed in all civilized states where slavery has been tolerated, are among the subjects upon which municipal legislation becomes necessary when slavery is introduced. Is it conceivable that the Constitution has conferred the right on every citizen to become a resident on the territory of the United States with his slaves, and there to hold them as such, but has neither made nor provided for any municipal regulations which are essential to the existence of slavery? Is it not more rational to conclude that they who framed and adopted the Constitution were aware that persons held to service under the laws of a state are property only to the extent and under the conditions fixed by those laws, that they must cease to be available as property when their owners voluntarily place them permanently within another jurisdiction, where no municipal laws on the subject of slavery exist, and that, being aware of these principles, and having said nothing to interfere with or displace them, or to compel Congress to legislate in any particular manner on the subject, and having empowered Congress to make all needful rules and regulations respecting the territory of the United States, it was their intention to leave to the discretion of Congress what regulations, if any, should be made concerning slavery therein. Moreover, if the right exists, what are its limits, and what are its conditions? If citizens of the United States have the right to take their slaves to a territory, and hold them there as slaves, without regard to the laws of the territory, I suppose this right is not to be restricted to the citizens of slave-holding states. A citizen of a state which does not tolerate slavery can hardly be denied the power of doing the same thing. And what law of slavery does either take with him to the territory? If it be said to be those laws respecting 60 U.S. 393, 626 slavery which existed in the particular state from which each slave last came, what an anomaly is this? Where else can we find, under the law of any civilized country, the power to introduce and permanently continue diverse systems of foreign municipal law, for holding persons in slavery? I say, not merely to introduce, but permanently to continue, these anomalies. For the offspring of the female must be governed by the foreign municipal laws to which the mother was subject, and when any slave is sold or passes by succession on the death of the owner, there must pass with him, by a species of subrogation, and as a kind of unknown use in re, the foreign municipal laws which constituted, regulated, and preserved the status of the slave before his exportation. Whatever theoretical importance may be now supposed to belong to the maintenance of such a right, I feel a perfect conviction that it would, if ever tried, prove to be as impracticable in fact, as it is, in my judgment, monstrous in theory. I consider the assumption which lies at the basis of this theory to be unsound, not in its just sense, and when properly understood, but in the sense which has been attached to it. The assumption is that the territory ceded by France was acquired for the equal benefit of all the citizens of the United States. I agree to the position, but it was acquired for their benefit in their collective, not their individual, capacities. It was acquired for their benefit, as an organized political society, subsisting as the people of the United States, under the Constitution of the United States, to be administered justly and impartially, and as nearly as possible for the equal benefit of every individual citizen, according to the best judgment and discretion of the Congress, to whose power, as the legislature of the nation which acquired it, the people of the United States have committed its administration. Whatever individual claims may be founded on local circumstances, or sectional differences of condition, cannot, in my opinion, be recognized in this court, without arrogating to the judicial branch of the government powers not committed to it, and which, with all the unaffected respect I feel for it, when acting in its proper sphere, I do not think it fitted to wield, nor, in my judgment, will the position that a prohibition to bring slaves into a territory deprives anyone of his property without due process of law, bear examination. It must be remembered that this restriction on the legislative power is not peculiar to the Constitution of the United States. It was borrowed from Magna Carta, was brought to America by our ancestors, as part of their inherited liberties, and has existed in all the states, usually in the very words of 60 U.S. 393, 627 the Great Charter. It existed in every political community. In America in 1787, when the ordinance prohibiting slavery north and west of the Ohio was passed, and if a prohibition of slavery in a territory in 1820 violated this principle of Magna Carta, the ordinance of 1787 also violated it, and what power had, I do not say the Congress of the Confederation alone, but the legislature of Virginia, of the legislature of any or all the states of the Confederacy, to consent to such a violation? The people of the states had conferred no such power. I think I may at least say, if the Congress did then violate Magna Carta by the ordinance, no one discovered the violation. Besides, if the prohibition upon all persons, citizens as well as others, to bring slaves into a territory, and a declaration that it brought they shall be free, deprived citizens of their property without due process of law, what shall we say of the legislation of many of the slave-holding states which have enacted the same prohibition? As early as October 1778, the law was passed in Virginia, that thereafter no slave should be imported into that commonwealth by sea or by land, and that every slave who should be imported should become free. A citizen of Virginia purchased in Maryland a slave who belonged to another citizen of Virginia, and removed with the slave to Virginia. The slave sued for her freedom, and recovered it, as may be seen in Wilson v. Isabel, 5 calls are 425. See also Hunter v. Halsher, 1 Leave, 172, and a similar law has been recognized as valid in Maryland, in Stewart v. Oaks, 5 Hart, and John, 107. I am not aware that such laws, though they exist in many states, were ever supposed to be in conflict with the principle of Magna Carta incorporated into the state constitutions. It was certainly understood by the convention which framed the Constitution, and has been so understood ever since, that, under the power to regulate commerce, Congress could prohibit the importation of slaves, and the exercise of the power was restrained till 1808. A citizen of the United States owns slaves in Cuba, and brings them to the United States, where they are set free by the legislation of Congress. Does this legislation deprive him of his property without due process of law? If so, what becomes of the laws prohibiting the slave trade? If not, how can similar regulation respecting a territory violate the Fifth Amendment of the Constitution? Some reliance was placed by the defendant's counsel upon the fact that the prohibition of slavery in this territory was in the words, that slavery, and seized, shall be and is hereby forever prohibited. But the insertion of the word forever can have no legal effect. Every enactment not expressly limited in its 60 U.S. 393, 628 duration continues in force until repealed or abrogated by some competent power, and the use of the word forever can give to the law no more durable operation. The argument is, that Congress cannot so legislate as to bind the future states formed out of the territory, and that in this instance it has attempted to do so. Of the political reasons which may have induced the Congress to use these words, and which caused them to expect that subsequent legislatures would conform their action to the then general opinion of the country that it ought to be permanent, this court can't take no cognizance. however fit such considerations are to control the action of Congress, and however reluctant a statesman may be to disturb what has been settled, every law made by Congress may be repealed, and, saving private rights, and public rights gained by states, its repeal is subject to the absolute will of the same power which enacted it. If Congress had enacted that the crime of murder, committed in this Indian territory, north of 36 degrees 30 minutes, by or on any white man, should forever be punishable with death, it would seem to me an insufficient objection to an indictment, found while it was a territory, that some future day states might exist there, and so the law was invalid, because, by its terms, it was to continue in force forever. Such an objection rests upon a misapprehension of the province and power of courts respecting the constitutionality of laws enacted by the legislature. If the Constitution prescribe one rule, and the law another and different rule, it is the duty of courts to declare that the Constitution, and not the law, governs the case before them for judgment. If the law include no case save those for which the Constitution has furnished a different rule, or no case which the legislature has the power to govern, then the law can have no operation. If it includes cases which the legislature has power to govern, and concerning which the Constitution does not prescribe a different rule, the law governs those cases, though it may, in its terms, attempt to include others, on which it cannot operate. In other words, this court cannot declare void an act of Congress which constitutionally embraces some cases, though other cases, within its terms, are beyond the control of Congress, or beyond the reach of that particular law. If, therefore, Congress had power to make a law excluding slavery from this territory while under the exclusive power of the United States, the use of the word forever does not invalidate the law, so long as Congress has the exclusive legislative power in the territory. 60 U.S. 393, 629. But it is further insisted that the Treaty of 1803, between the United States and France, by which this territory was acquired, has so restrained the constitutional powers of Congress, that it cannot, by law, prohibit the introduction of slavery into that part of this territory, north and west of Missouri, and north of 36 degrees 30 minutes north latitude. By a treaty with a foreign nation, the United States may rightfully stipulate that the Congress will or will not exercise its legislative power in some particular manner, on some particular subject. Such promises, when made, should be voluntarily kept, with the most scrupulous good faith. But that a treaty with a foreign nation can deprive the Congress of any part of the legislative power conferred by the people, so that it no longer can legislate as it was empowered by the Constitution to do, I more than doubt. The powers of the government do and must remain unimpaired. The responsibility of the government to a foreign nation, for the exercise of those powers, is quite another matter. That responsibility is to be met, and justified to the foreign nation, according to the requirements of the rules of public law, but never upon the assumption that the United States had parted with or restricted any power of acting according to its own free will, governed solely by its own appreciation of its duty. The second section of the fourth article is, this Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. This has made treaties part of our municipal law, but it has not assigned to them any particular degree of authority, nor declared that laws so enacted shall be irrepealable. No supremacy is assigned to treaties over acts of Congress. That they are not perpetual, and must be in some way repealable, all will agree. If the President and the Senate alone possess the power to repeal or modify a law found in a treaty, inasmuch as they can change or abrogate one treaty only by making another inconsistent with the first, the government of the United States could not act at all, to that effect, without the consent of some foreign government. I do not consider, I am not aware it has ever been considered, that the Constitution has placed our country in this helpless condition. The action of Congress in repealing the treaties with France by the Act of July 7, 1798, 1 Stat. At large, 578, was in conformity with these views. In the case of Taylor et al. V. Morton, 2 Curtis of Sir I.R. Coulthard, 60 U.S. 393, 630-454, I had occasion to consider this subject, and I adhere to the views there expressed. If, therefore, it were admitted that the treaty between the United States and France did contain an express stipulation that the United States would not exclude slavery from so much of the ceded territory as is now in question, this court could not declare that an act of Congress excluding it was void by force of the treaty. Whether or no the case existed sufficient to justify a refusal to execute such a stipulation would not be a judicial, but a political and legislative question, wholly beyond the authority of this court to try and determine. It would belong to diplomacy and legislation, and not to the administration of existing laws. Such a stipulation in a treaty, to legislate or not to legislate in a particular way, has been repeatedly held in this court to address itself to the political or the legislative power, by whose action thereon this court is bound. Foster v. Nicholson, 2 Peters, 314, Garcia v. Lee, 12 Peters, 519. But, in my judgment, this treaty contains no stipulation in any manner affecting the action of the United States respecting the territory in question. Before examining the language of the treaty, it is material to bear in mind that the part of the ceded territory lying north of 36 degrees 30 minutes, and west and north of the present state of Missouri, was then a wilderness, uninhabited save by savages, whose possessory title had not then been extinguished. It is impossible for me to conceive on what ground France could have advanced a claim, or could have desired to advance a claim, to restrain the United States from making any rules and regulations respecting this territory, which the United States might think fit to make, and still less can I conceive of any reason which would have induced the United States to yield to such a claim. It was to be expected that France would desire to make the change of sovereignty and jurisdiction as little burdensome as possible to the then inhabitants of Louisiana, and might well exhibit even an anxious solicitude to protect their property and persons, and secure to them and their posterity their religious and political rights, and the United States, as a just government, might readily accede to all proper stipulations respecting those who were about to have their allegiance transferred. But what interest France could have in uninhabited territory, which, in the language of the treaty, was to be transferred forever, and in full sovereignty, to the United States, or how the United States could consent to allow a foreign nation to interfere in its purely internal affairs, in which that foreign nation had no concern. 60 U.S. 393, 631 whatever, is difficult for me to conjecture. In my judgment, this treaty contains nothing of the kind. The third article is supposed to have a bearing on the question. It is as follows: the inhabitants of the ceded territory shall be incorporated in the Union of the United States, and admitted as soon as possible, according to the principles of the Federal Constitution, to the enjoyment of all the rights, advantages, and immunities of citizens of the United States. And in the meantime they shall be maintained and protected in the enjoyment of their liberty, property, and the religion they profess. There are two views of this article, each of which, I think, decisively shows that it was not intended to restrain the Congress from excluding slavery from that part of the ceded territory then uninhabited. The first is, that, manifestly, its sole object was to protect individual rights of the then inhabitants of the territory. They are to be maintained and protected in the free enjoyment of their liberty, property, and the religion they profess. But this article does not secure to them the right to go upon the public domain ceded by the treaty, either with or without their slaves. The right or power of doing this did not exist before or at the time the treaty was made. The French and Spanish governments, while they held the country, as well as the United States when they acquired it, always exercised the undoubted right of excluding inhabitants from the Indian country, and of determining when and on what conditions it should be opened to settlers. And a stipulation, that the then inhabitants of Louisiana should be protected in their property, can have no reference to their use of that property, where they had no right, under the treaty, to go with it, save at the will of the United States. If one who was an inhabitant of Louisiana at the time of the treaty had afterwards taken property then owned by him, consisting of firearms, ammunition, and spirits, and had gone into the Indian country north of 36 degrees 30 minutes, to sell them to the Indians, all must agree. The third article of the treaty would not have protected him from indictment under the Act of Congress of March 30, 1802, to sit at large, 139, adopted and extended to this territory by the Act of March 26, 1804, to sit at large, 283. Besides, whatever rights were secured were individual rights. If Congress should pass any law which violated such rights of any individual, and those rights were of such a character as not to be within the lawful control of Congress under the Constitution, that individual could complain, and the act of Congress, as to such rights of his, would be inoperative, but if 60 U.S. 393, 632 would be valid and operative as to all other persons, whose individual rights did not come under the protection of the treaty. And inasmuch as it does not appear that any inhabitant of Louisiana, whose rights were secured by treaty, had been injured, it would be wholly inadmissible for this court to assume, first, that one or more such cases may have existed, and, second, that if any did exist, the entire law was void not only as to those cases, if any, in which it could not rightfully operate, but as to all others, wholly unconnected with the treaty, in which such law could rightfully operate. But it is quite unnecessary, in my opinion, to pursue this inquiry further, because it clearly appears from the language of the article, and it has been decided by this court, that the stipulation was temporary, and ceased to have any effect when the then inhabitants of the territory of Louisiana, in whose behalf the stipulation was made, were incorporated into the Union. In the cases of New Orleans v. Armis et al., 9 Peters, 223, the question was, whether a title to property, which existed at the date of the treaty, continued to be protected by the treaty after the state of Louisiana was admitted to the Union. The third article of the treaty was relied on. Mr. Chief Justice Marshall said, this article obviously contemplates two objects. 1. That Louisiana shall be admitted into the Union as soon as possible, on an equal footing with the other states, and the other, that, till such admission, the inhabitants of the ceded territory shall be protected in the free enjoyment of their liberty, property, and religion. Had any one of these rights been violated while these stipulations continued in force, the individual supposing himself to be injured might have brought his case into this court, under the 25th section of the Judicial Act. But this stipulation ceased to operate when Louisiana became a member of the Union, and its inhabitants were admitted to the enjoyment of all the rights, advantages, and immunities of citizens of the United States. The cases of Shoto v. Margarita, 12 Peters, 507, and Thermale v. New Orleans, 3 House, 589, are in conformity with this view of the treaty. To convert this temporary stipulation of the treaty, in behalf of French subjects who then inhabited a small portion of Louisiana, into a permanent restriction upon the power of Congress to regulate territory then uninhabited, and to assert that it not only restrains Congress from affecting the rights of property of the then inhabitants, but enabled them and all other citizens of the United States to go into any part of the 60 U.S. 393, 633 ceded territory with their slaves, and hold them there, is a construction of this treaty so opposed to its natural meaning, and so far beyond its subject matter and the evident design of the parties, that I cannot assent to it. In my opinion, this treaty has no bearing on the present question. For these reasons, I am of opinion that so much of the several acts of Congress as prohibited slavery and involuntary servitude within that part of the territory of Wisconsin lying north of 36 degrees 30 minutes north latitude, and west of the river Mississippi, were constitutional and valid laws. I have expressed my opinion, and the reasons therefore, at far greater length than I could have wished, upon the different questions on which I have found it necessary to pass, to arrive at a judgment on the case at bar. These questions are numerous, and the grave importance of some of them required me to exhibit fully the grounds of my opinion. I have touched no question which, in the view I have taken, it was not absolutely necessary for me to pass upon, to ascertain whether the judgment of the Circuit Court should stand or be reversed. I have avoided no question on which the validity of that judgment depends. To have done either more or less, would have been inconsistent with my views of my duty. In my opinion, the judgment of the Circuit Court should be reversed, and the cause remanded for a new trial.